Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated. This matter is Mary Scott versus the Pennsylvania Board of Probation and Parole. Representing Ms. Scott is Mr. Brett Grody. Representing the board is Mr. Ronald Eisenberg.
Before we begin your oral argument, we moved this case to the front because staff was told that there may be larger public interest in it than is typical, and we wouldn't want to inconvenience so many members of the public who apparently did not come, but that's just fine. But we'll hear this, then we'll hear the balance of our cases, beginning with the first case through the fourth case. Second day of our oral argument in Pittsburgh. Welcome, everybody. Mr. Groth, is that correct?
Grody, Your Honor.
Grody, I apologize. Would you like to present your argument?
Correct.
I fixed it on my sheet. Please feel free to proceed. Let me explain what the case is about.
Thank you.
There's several incarcerated individuals, all convicted of felony murder, currently serving a sentence of life. They filed a petition for review challenging Pennsylvania Board of Probation and Parole's enforcement of the parole code's preclusion of parole to those serving a life sentence for a felony murder. They argue that a life sentence under these circumstances, as applied in these circumstances, violates both the Eighth Amendment, cruel and unusual punishment, the United States Constitution, and the cruel provision in the Article 1, Section 13 of the Pennsylvania Constitution. The Commonwealth Court dismissed their petition on jurisdictional grounds, finding that their claims were actually a collateral attack on their sentences and therefore fell within the exclusive ambit of the PCRA. The direct appeal appellants asked us to consider whether the Commonwealth Court was in error in construing their complaint as a challenge to the legality of sentence, which must otherwise be channeled through the PCRA and not through this argument. So if that's what this is all about, tell us why the Commonwealth Court was wrong.
Thank you, Your Honor. I'd be happy to. I do want to just begin with one clarification, which is that both of our constitutional claims were brought under the Pennsylvania Cruel Punishment Clause. We use much of the federal jurisprudence from the Cruel and Unusual Punishment Clause for recognizing that that sets a floor for the Cruel Punishments Clause. And then our second clause is brought pursuant to the Edmunds factor. But to get to the issue before this court today, the jurisdictional question, first I'd like to acknowledge that this case may feel to some of you different than what we think it is, this jurisdictional question. Life without parole is a common discursive linking. It's thought of as a single concept in the way that it's experienced by petitioners, but life without parole is actually a construct that has two components. One is the sentence that is imposed by the criminal court in Pennsylvania, which is a sentence of life imprisonment. The without parole component resides in the parole code. As we briefed under the 6137A statute, it is the parole code that denies parole eligibility to individuals who are serving life sentences. It is our position that in solely challenging the without parole aspect of this construct, the life imprisonment sentence will remain in place. Now, the Commonwealth Court held that, consistent with Appellee's arguments, that a challenge to the 6137A parole code statute was inextricably intertwined with a challenge to the 1102. That was the exact phrase that they used. I believe that cannot be squared with this court's analysis of the same statutory code in the Batts case from 2013. In Commonwealth v. Batts in 2013, a case that Appellee is very familiar with, he was one of the counsel for the Commonwealth. The Commonwealth was arguing with Mr. Batts' counsel as to what was the appropriate remedy for a life sentence that was imposed pursuant to a mandatory sentencing scheme after the ruling in Miller v. Alabama. And this was on direct appeal, not implicating the PCRA. The Commonwealth argued that the change to the sentencing scheme was minimal, that only through the parole code was the proscription of Miller, and the Juvenile Act, which is not at issue in our case, was the proscription of Miller squarely triggered, that the statutes were severable, and that allowing for parole in that instance would leave the 1102 sentence of life imprisonment, quote, unaltered. And that was not just the Commonwealth's argument, that was the argument that was adopted by this court. Now, if the 1102 statute would be unaltered, because it can be severed from the scheme, then it is not inextricably intertwined. The construction of statute 1 PACS 25, which you're all familiar with, so I'm not going to recite it for you, recognizes that if a statutory provision were removed and it would leave another statute or statutory provision incomplete, such that the legislature would have rather preferred no statute to any statute, in that case, if they were so mutually dependent on each other, they would both fall. But under this court's assessment in Commonwealth v. Batts, these are severable statutes.
Counsel, can I? Let me follow up with you on that, because we have a little bit more than our opinion in Commonwealth v. Batts. We also have the legislature's reaction to Miller and Montgomery, and they certainly viewed life to mean life without parole when they created a new statute that said a minimum sentence, depending on the age of a juvenile, to life. That is impossible to read any other way than an expression of the legislature's intention that life meant life without parole, because they said a minimum.
Correct. We are not challenging the legislative intent in the life imprisonment statute.
But doesn't it go to the point that the without parole aspect of the sentence is indeed part of the legislative scheme?
It is part of the scheme. Our position.
Sentencing scheme.
So it is part of the scheme. If it's referred to as a sentencing scheme, I do want to unpack what I understand sentencing scheme to mean through the teachings of this court. The sentence is what is imposed by the trial court. The manner of executing the sentence, questions of penal administration, prison discipline, etc., those are not inherently judicial functions. And in the without parole component of the construct, as this court recognized as Batts, resides in the parole code 6137A statute that petitioners challenge here. With our constitutional claims, we are not saying that the life sentence, the lifetime prohibition on parole eligibility for those convicted of felony murder is somehow not what the legislature intended. In assessing the constitutionality of legislative acts, right, or in this case, an agency's enforcement of legislative acts, this court looks at the manner in which the legislative will is enforced to assess whether it is encroached upon a constitutional right, not what the intent is behind that. The sentencing court imposes a sentence of life imprisonment. The regulation of parole, and this is why I want to get back maybe to the difference between what the case feels like versus what it is. In, say, an indeterminate sentencing scheme, right, where the court will set somewhere a minimum and a maximum, the legislature has decided that there will be an exercise of judicial discretion in determining when individuals' sentenced to indeterminate schemes are to be parole eligible, right? So it's very common for us to think that the parole eligibility question is something that is addressed by the trial court, because it often is actually in the majority of sentences, including sentences of incarceration. But the legislature has effectuated its will in a different manner in regard to flat, definite life sentences. The court imposes a sentence of life imprisonment. The parole code enforces the without parole component, as this court recognized in Batts.
But there, as Justice Donahue said to you, I think, eloquently and sophisticatedly, and I thought about it sort of more basically. The legislature passed 6137. It passed 1102. It knew that they were comparative statutes. They're to be read in pari materia, and you have a complete sentencing code. The only question before us, our question before us is not whether or not the sentencing code as applied to your clients is cruel under Article 1, Section 13. The question before us is, can you bring that in this fashion, or do you have to go get a new plaintiff and do it through direct appeal or PCRA?
I agree that is absolutely the question, right? We believe that the claim that we have brought cannot be brought as a PCRA for a couple of reasons. One, we cannot sue the parole board for enforcing the parole code through a PCRA. That's not a viable action. But
you're saying you're in a heads I win, tails I lose, heads I lose position, because if you can't bring it this way and you can't bring it under PCRA, you have to have a remedy for this right.
I believe that, that is a basic principle of law. There are remedies for rights. But I also want to get to maybe the other reason that I think is important to that this cannot be brought as a PCRA. If we were to challenge which we are arguing that we're not doing here, right? But if there were, say, a challenge to the 1102 statute, our petitioners, and let's leave aside the timeliness considerations, right? Let's pretend it's a timely PCRA in this hypothetical. And our petitioners say the lack of a minimum sentence in our cases is unconstitutional. There's binding precedent, at least one published opinion of the Superior Court and two more that followed up on it, which said PCRAs seeking a minimum sentence for life-sentenced prisoners are not challenges to the lawful maximum. And that is a requirement under the PCRA. One caveat there is that those were challenges that the sentencing scheme was void for vagueness. The Moore case that Aplt cited, and this court decided, I believe recognized that a void for vagueness challenge actually is a challenge, right, to a sentence that's greater than the maximum, because a vague statute, if it's so vague that it is void, it is a legal nullity, no statute at all.
But counsel, that void for vagueness challenge was tied to the parole enforcement portion of the sentencing scheme for life without parole.
It sought a minimum sentence, was my understanding, and the court found that it was not vague. What I'm trying to extrapolate, though...
Just if I can follow up, because I think this ties together, and I understand your argument, and it's clever, but that void, it was found not to be void for vagueness because of the life without parole aspect of the sentencing scheme. Correct?
There was nothing about the scheme that was challenged that was vague, right? And we're not alleging that. I was just wanting to distinguish that case in which Superior Court adjudicating similar challenges has held you can't challenge the lack of a minimum sentence in a PCRA because you're not challenging the lawful maximum. So if we were to bring claims seeking the same relief in a PCRA seeking a minimum, at least as the Superior Court's recent case law would suggest, that's not permissible under a PCRA or habeas corpus, of course, is subsumed by the PCRA. The jurisdictional question in front of the court is, can we proceed in the Commonwealth Court, or is this sound in the application of a PCRA or habeas corpus? I don't see, leaving aside the timeliness issues, any way to challenge a sentence when you're not challenging something that's greater than the lawful maximum. And this is where this court's teachings for over 100 years about the maximum sentence being the true sentence and the only portion of the sentence with legal validity is really critical. Because if you're challenging the lack of a minimum, as we were essentially doing through the parole code, right, not being parole eligible, the maximum sentence is in place. That is, in the words of this court, the only portion of the sentence with legal validity. If the life imprisonment sentence, and here I want to be clear, parole is a legal imprisonment. That is, in the words of this court, in the Kane case, quoting the U.S. Supreme Court, other cases have recognized it. The Martin v. Pennsylvania Board of Probation and Parole case, I believe, said it was a variation on imprisonment. Being parole eligible would not alter the fact that petitioners were subject to a sentence of life imprisonment. If the relief sought would not do anything to disturb the sentence imposed by the criminal court, then it is a permissible action in the Commonwealth Court to sue an agency for enforcement of the statute that it is exclusively tasked with enforcing.
Tell me again, if you would, and I apologize that I don't understand it, but it's important that I understand it so I can cast an intelligent vote here. Why, on direct appeal or on PCRA, can you not mount a cruel, let's say a cruel and unusual punishment argument?
So
I don't think I buy, just to narrow the question a little bit.
Correct.
I don't think I buy that there's no maximum. It seems to me if the maximum is you're carried out of jail dead, that the court would construe that as cognizable.
So I do want to draw a distinction between direct appeal and PCRA, because the Commonwealth Court's jurisdictional statute makes no reference to what can be challenged at the trial court level in direct appeal. So I do not believe, under the plain text of the statute, what could be brought in a direct appeal is at issue in this case. It is about making sure that collateral attacks on convictions or sentences go through the PCRA. Okay. So why can't this challenge be brought under the PCRA? The Superior Court says seeking a minimum as relief is not permissible because it is not a challenge to the lawful maximum. Now, Your Honor might disagree with the Superior Court, and maybe 4 of the 7 here would disagree with the Superior Court on that point. That's the state of the law as we found it with the cases cited in Appellant's brief. That is also requiring us to challenge the 1102, the action of the sentencing court. Here's where I would like to, if I could, discuss the United States Supreme Court's discussion in Montgomery v. Louisiana of the rule of Miller v. Alabama. As we also know, I think another reason this case really feels like the challenge to the sentence imposed by the criminal court, or it may to some of you, is because after the Miller case and then the Montgomery case, resentencings in Pennsylvania were carried out through, for those cases not on direct appeal, through the PCRA. And we believe that the rule of Miller is distinct from the relief we're seeking here insofar as we're not invoking the procedural component of Miller, which invalidated sentencing schemes that would have resulted in life without parole that were imposed in a mandatory nature. That meant all the life sentences that had been imposed prior to Miller in Pennsylvania were invalidated, entitling people to resentencing. But the U.S. Supreme Court in Montgomery itself acknowledged relitigating sentences was not necessary to remedy the proscription of Miller, that individuals, defendants, could be granted parole. That is not how it happened in Pennsylvania, but I want to posit another hypothetical. Maybe a journalist covers this, and the legislature decides that they want to address this issue. They want to give you all a break from writing an opinion, and they want to allow parole eligibility. They draft something up, and Monday they pass it, and it sails through. They alter the parole code. So it says individuals who did not, who are serving sentences for felony murder, and they could work out all the specific language, serving life sentences, will be parole eligible if they're over 18, just like if they're under 18, after 25 years. They alter the parole code. Is that a permissible reform from the legislature? I think it is. I don't think it's controversial. If the legislature would have tried to enact the same reform by saying all individuals sentenced to life for felony murder, for second-degree murder, are hereby resentenced to 25 to life, right? Or their sentences must be vacated upon a petition and a new sentence imposed, that would not be permissible if they effectuate their will in that manner, because it would disturb the finality of the criminal court's judgment. So it's different ways of trying to effectuate the same remedy. Sutley goes to this point, right? The Sutley case from 1976, which we briefed in our reply brief, dealt with the legislature's attempt to change penalties for marijuana possession. And there was some mandatory language in Sutley that individuals would be resentenced. And the Supreme Court said, you cannot do this, right? You cannot disturb the finality of a judgment of a court by a retroactive alteration of the Crimes and Offenses Code in that instance. But they did recognize in discussing the Kane Court, quote, the Kane Court properly concluded those portions of the statute which did not alter the judicial decision as to the length of time of state control over the offender did not impinge upon traditional judicial sentencing power and thus did not alter or modify the judicial sentence which had become final. On the other hand, the court found that unconstitutional those provisions of the act in question which would have permitted an alteration of the duration of the sentence. In this instance, the sentence, recognized as the entire period of control over the defendant, could encompass whether that sentence is served on parole, whether it's served in a halfway house, whether it's served in a state correctional institution. These are questions of penal administration and prison discipline that can be altered without disturbing the sentence that was imposed by the criminal court.
Just one more time before you sit down, so I have it straight. You concede that a defendant could attack a sentence as cruel on direct appeal. If, for instance, a trial judge ordered that the defendant be burned at the stake or guillotined, that could be challenged as an unlawful sentence. So, absolutely, and I believe such a sentence that you just articulated could be challenged in a PCRA. It might even win, but go ahead.
I would hope so. On direct appeal, I believe that a challenge to the lack of a minimum is cognizable. In a PCRA, I do not believe it is.
If not to be facetious, but if a trial court sees a peculiar crime and gets angry and sentences the individual to death by slow torture, that's reversible on direct appeal, is it not?
Yes.
You don't have to wait for a PCRA to challenge that as unlawful?
Correct, but the jurisdictional statute governing what the Commonwealth Court can hear refers to whether the case can be brought in a PCRA or a habeas corpus.
Right, I agree with that. So that could be heard on direct appeal. Frankly, it's a capital case that would come directly to us for mandatory review, and we could reverse that without jurisdictional impediment. It can also be brought through the PCRA under those circumstances, right?
Under those circumstances, which are not circumstances challenging the lack of a minimum, right? So the PCRA, you can challenge sentences. You can't challenge the manner in which the sentence is executed, say by actions of the parole board, right? Or actions of the Department of Corrections or other factors that go to penal administration.
That's the linchpin of what you're arguing here.
Precisely.
I get it. Any questions?
Go ahead.
No, I'm done.
Help me overcome this hurdle. The parole board is an administrative agency. The administrative agency is only permitted what the legislator is permitted to do. 6137 gives it its restrictions, that it's not to consider parole for life without imprisonment. How is this just, again, in a very pedestrian way, how is this just not a collateral attack on the sentence? This is, unless you're taking an administrative challenge. I don't see an administrative challenge rising to the level of a constitutional issue.
So it's not an attack on the sentence for reasons that I've already stated, but I want to get at it a different direction to see if this helps our position at all. So let's say that this case is allowed to proceed and petitioners win on one of their claims, and a remedy is thereby fashioned. Maybe the remedial phase is paused and the legislature says after 20 years, parole eligibility. Or maybe the legislature doesn't act and they hear from the parties and there's an injunctive order that regulates when people will be parole eligible that are serving life sentences for felony murder. That injunctive order would be de facto the equivalent of a minimum, what this court has called a minimum sentence, what's referred to as a minimum sentence. Here's where the technical meaning of minimal sentence informs our argument. This court has said repeatedly, a minimum sentence is a, quote, mere administrative notice. It's a notice from the judiciary to the parole board of when somebody will be considered parole eligible. It does not alter the fact or duration of the true sentence, the only portion with legal validity, the maximum sentence. So we believe the question is, could a remedial court that is fashioning relief for one or both of our claims issue injunctive relief in the form of, that's the equivalent of an administrative notice? In an administrative notice, in that the way that has been used to refer to a minimum sentence is a very technical distinction from the maximum sentence, which is recognized as the core of the judicial responsibility.
I like your argument. The question I have is, doesn't Hudson, our decision in Hudson, throw a wrench into your argument? You say life means life.
I'm very glad that you brought up Hudson, because I think it supports our jurisdictional argument, because you adjudicated a challenge to 6137A. Hudson had a statutory construction argument, right? And statutory construction, I believe that it is absolutely the case in Pennsylvania, looking at the way the legislature has laid out the statutory code. Life imprisonment imposed by 1102 means without parole through the parole code. That's the intent, that's the structure. A constitutional challenge, however, if successful, in showing that the manner in which this is imposed would require the statutes to have to be struck down as void for violating a constitutional provision. The Constitution trumps the statutes.
And that's how you get at A3, that latter part?
The minimum, correct, because if you had to fashion a remedy and then the court trying to fashion a remedy would run into the statutory requirements, oh wait, what's their minimum? Their minimum's life. That would pose an identical constitutional question, right? You can't, because it would essentially be saying you can't consider them for parole eligibility until they've served their life sentence. But if we're in the remedial phase, we've already won that question, that the denial of parole eligibility would constitute cruel punishment, and we believe that the statute would have to fall for the constitutional command.
Counsel, before you move on from Hudson, I'm not quite certain how Hudson supports your jurisdictional issue. Hudson was based upon a denial of an application for parole. So it was a direct appeal. What you're doing here is a very different scenario, where you're raising the issue in the first instance in the Commonwealth Court. There was a denial of parole in Hudson. There was an appeal from that denial to the Commonwealth Court, correct? It had nothing to do with legality or not illegality of sentence. I mean, it may internally have had something to do with that, but procedurally, it was a direct appeal.
So maybe we filed in the original jurisdiction of the Commonwealth Court, but maybe this got lost in the briefing. Our petitioners all sought parole review. They applied for parole review to the parole board, and the parole board issued letters saying, we are not considering you because of 6137A.
And you appealed from that, as was the case in Hudson?
We filed in the court's original jurisdiction. I don't believe that there was an administrative appeal in that instance. Mr. Hudson, I can't speak to his litigation decisions. We think it affects our jurisdictional issue because if Appellee's argument was accurate, this court would have said, wait, he's attacking the 6-1, he's sentenced to life, he's convicted of felony murder, that's not disputed in Hudson. He can't seek parole eligibility in a suit against the Commonwealth or against the parole board in the Commonwealth Court. That has to be brought in a challenge in the criminal court. But this court didn't do that. You adjudicated the statutory construction issue. So the fact that we have a constitutional claim, it's different than the statutory construction issue, but this court did adjudicate the parole board's enforcement of this statute, which we believe is a very conventional and well-established way to challenging agency action.
Can I just follow up on it? Can you, could you account for the disparity in the Commonwealth Court's treatment of Hudson in this case? In other words, the Commonwealth Court in Hudson never suggested that Hudson had to go through the PCRA, but here it did. How would one explain that?
I think that it might be a little bit foolish for me to speculate as to what one panel did versus another panel. I'm not sure, right? I certainly know that I don't know if jurisdiction was raised by the other side, right? It certainly was raised and argued vigorously below in this matter. This court and the Commonwealth Court recognize that jurisdiction is a question the courts must police even at the highest levels. So I'm not sure why they didn't address it there.
Can I speculate?
Certainly am.
Let me speculate. I think it was because it was an appeal from the denial of parole by the parole board. And then it came to us as a direct appeal from a determination of the Commonwealth Court. Now, I could be wrong, but I mean, to me, I think that's what happened. I mean, there was a different, and maybe counsel for the Commonwealth has more insight into that, but as I read Hudson, the procedural posture of it coming up through the intermediate appellate court and then to us on direct appeal takes it out of the situation that we're dealing with here.
I think that's a distinction, but I don't think that it affects the jurisdictional question, because if Mr. Hudson were to challenge, I don't think you can have a collateral attack on the sentence that would be cognizable in a PCRA challenged in court, even in a direct appeal. The Commonwealth Court, you know, if that's what you're saying the distinction is, then we can file a direct appeals. We can have our petitioners, I understand, but we can have our petitioners seek parole again. It's denied. We can go through the other procedural mechanism. I still think the other side is going to argue the jurisdictional point that this is an attack on the sentence.
Could be, but I mean, in answer to the question, why did they treat it differently? That may be a reason why they.
It could be. I mean, I could, since we're speculating, maybe they just thought the 6137A statute was so clear in precluding parole eligibility that they thought they could just dismiss it that way without dealing with any knotty issues, even though that's technically not what they're supposed to do when they don't have jurisdiction.
That's technically what we're not supposed to do either. I mean, we're supposed to raise jurisdiction sua sponte.
Right, which is why we like to be able, and we like to argue that you were correct, because that's usually what you like to argue when you're in front of the Supreme Court or any court, is that you were correct. Hudson, of course, was something that you had the jurisdiction to adjudicate, just like you would in our case here.
Thank you very much, Mr. Grody.
Thank
well
you.
Said. Mr. Eisenberg?
May it please the court, if this case feels like life imprisonment equals life without parole, that's because Pennsylvania law clearly says that life imprisonment in and of itself precludes parole. And the significance of that is that because it is part of the sentence, it can be challenged in the PCRA and only through the PCRA, the sole means of the PCRA. I'll address both points.
Mr. Eisenberg, would you pull your microphone closer to you?
My apologies, Your Honor.
It's all right.
As this court held just several months ago in the Cobbs case, life imprisonment, quote unquote, means exactly that, a lifetime of incarceration without parole. Quote, an inmate cannot simultaneously be both a life prisoner and parole eligible.
But that's, fair point, but that's by operation of two distinct statutes.
No, Your
And
Honor.
this- No?
I'm
The
sorry.
parole code, the parole code section 6137 and Crimes Code 1102 are the same statute?
I disagree that that was the holding in Cobbs, Your Honor. Cobbs relied solely on the sentencing statute at issue there, 2704 of the Crimes Code, which is identical in relevant terms to the statute at issue here, 1102. Both use the exact same phrase, life imprisonment. Cobbs did not rely on 6137, barely even cited the provision. In Hudson, 6137 was discussed more. You will recall that you filed a separate opinion arguing that the court should rely only on 6137. The court disagreed with your position and instead relied on 1102, relying on...
Sometimes. I guess to follow up, that the point of this case seems to be the argument that they ought to be able to bring in the Commonwealth Court's original jurisdiction a constitutional challenge to 6137 of the parole code that rises or falls on its merits or lack thereof down the line without the need for any challenge to the sentence or to the crimes code. In other words, if down the line they were to prevail on their cruel and unusual punishments argument, then they'd presumably be parole eligible, but that proceeds without regard to the sentencing regime. So why is that incorrect?
That's their argument, Your Honor, and it's wrong because of Cobbs, because of Moore, because of Hudson, and even because of 6137 itself. Petitioners have spoken throughout this litigation and today about 6137A, but there are actually two separate subdivisions of 6137A. One specifically deals with life imprisonment, but subsection A3 specifically says that the board has no power to parole until only after the expiration of the minimum term of imprisonment fixed by the court in its sentence. Now, the significance of that provision is that it underscores the fact that the ineligibility for parole is a part of the sentence and therefore a challenge to the authority of the court to not impose a minimum sentence is a challenge to the legality of the sentence, and a challenge to the legality of the sentence is cognizable under the PCRA and not in Commonwealth Court. Now, my colleague has said you might disagree with the Superior Court cases that hold that such a challenge is not cognizable under the PCRA. And the reality is that you already have disagreed with the Superior Court's holding in that regard. The leading Superior Court case was Commonwealth versus Rouse, which this court addressed at great length in its opinion just a year ago in Commonwealth versus Moore. And the court said Rouse was wrong. We reject the Superior Court's ruling in Rouse. A challenge to the legality, to the authority of the court to impose a minimum sentence is a challenge to the legality of the sentence and therefore is cognizable under the PCRA.
Mr. Eisenberg, you want to read 1102 and 6137 as if they're one statute. Isn't that fair?
Well, I think, Your Honor, that if either statute didn't exist, the answer would still be the same. And that's the significance of Hudson and Moore. Both of them relied on 1102 without regard to 6137.
Let me channel Justice Wecht, who I greatly admire. If 6137 did not exist, we'd have 1102 and we'd have a statutory interpretation problem with what does life imprisonment mean. We might have an ambiguous statute. The AG would be here arguing that obviously life imprisonment means until you're dead, and the defenders associations of our world would be arguing, surely if they wanted to say that, they could have added the extra words, and they didn't add the extra words, so they didn't mean that just that would be it. And the parole board, again, assuming 6137 doesn't exist, at some point can give parole. And I think that would be something that we'd have to entertain because we'd have an ambiguous statute. Ergo, 6137 is the complement to 1102, which makes it an unambiguous statutory scheme.
Your Honor, you wouldn't have to address those questions of 6130 as if 6137 didn't exist, because you already have. In Cobbs, you did not rely on 6137. You relied only on the Crimes Code. And in Hudson, you primarily relied on the Crimes Code. And you acknowledged that in and of itself there might be some ambiguity in that statute, but you resolved that ambiguity through the rules of statutory construction to hold that the statute in and of itself in the Crimes Code was sufficient to create a bar to eligibility for
Taken to
parole.
an extreme then, if I could test that, would you suggest that we could just dump the parole code? Because under your argument, the Crimes Code would take care of everything, providing there were sentencing provisions for whatever offense you're talking about. The parole code would be surplusage. I mean, in other words, at its limits, your argument seems to, on the other end, disregard the authorities that provide that parole is state custody. It's just in a different condition.
Not at all, I think, Justice Wecht. The parole code is written to reflect the reality of Pennsylvania sentencing law, which is that judges set minimum sentences, not the parole code. And so what the code and the sentencing law of Pennsylvania does as a whole is to distinguish between the exercise of discretion to grant parole, which belongs to the board, and the discretion to set an eligibility date for parole, which belongs exclusively under Pennsylvania law to the trial court. Now, I know that there are jurisdictions where it's different, and the United States Supreme Court recognized that in the Montgomery case when it said some states may want to do this a different way. But they didn't say that the states have to overrule all of their state law in order to do it the way that the petitioners want them to do it. In the federal system, for example, which I'm not very familiar with, I believe that judges do not set a parole eligibility date, and that's all up to the Bureau of Prisons. That's just not Pennsylvania law, and that's why this claim fails. Now, as far as the legislative intent is concerned, as I've said, this court has repeatedly interpreted the statutes, specifically the Crimes Code, to preclude parole eligibility, and 6137, which mirrors that. And as you, Justice Wecht, wisely stated at the end of your opinion in the Hudson case, if the legislature thinks that we're wrong in understanding their intent about the availability of parole eligibility for a life sentence, they can change the statute. They haven't done that, and I think that they clearly believe that the court has correctly interpreted the existing law. They may choose to change that law in the future, but that would be a matter of policy. It is clear what the existing law is. Speaking further to Hudson, Your Honor, it's important to recognize that in Hudson, this court's jurisdiction was not in question. Arguably, the Commonwealth court's jurisdiction might have been in question, but there was a threshold question, which was, what is the meaning of life imprisonment? And for this court, that was a matter of first impression. The court hadn't addressed that before. So it was only after this court's ruling in Hudson that there might have been a jurisdictional argument under this court's precedent about Commonwealth court's ability to review this sort of an issue. In any case, it is clear that Hudson held that 1102 life imprisonment precludes eligibility for parole, and it is the petitioner's position that you should ignore the holding that you actually announced in Hudson in favor of a holding that you didn't say anything about concerning jurisdiction. I don't think that the court can or should do that. One more point about A3, I think, Your Honor, as you've acknowledged, Justice Wecht, A3 is significant, but I think it cuts against the defendant because it is simply, the petitioners, because it is simply further indication that the sentencing structure of Pennsylvania gives the power to set parole eligibility dates to the trial court. In the case of life imprisonment, the legislature has withheld that power. A challenge to the court's authority, to the authority of any court, to impose such a sentence is a challenge to the legality of the sentence. It does not matter whether that's a Miller claim or a Montgomery claim or an Edmonds claim or a Graham claim. Whatever the petitioners wish to call it, it is still a categorical challenge, in their own words, a categorical challenge to the authority of the court not to set a sentence for parole eligibility.
Let me ask you, because it sort of reminds me of your floodgates argument. This case, unlike the other ones that have come before that you're talking about, is one in which petitioners are focusing on the parole code and asserting that they're not challenging, that they're not mounting a collateral attack on their sentence. You say in your brief that this would obliterate the PCRA's jurisdictional boundaries. And I want to ask you how that is the case. Which other PCRA claims could be raised in the Commonwealth Court that, other than this one, in other words, that could be remedied without vacating a sentence? In other words, they're saying they're not asking to vacate their sentence. They're asking to be able to mount a constitutional challenge and have that tested.
Your Honor,
And what are these other PCRA claims that you are talking about that could be raised and that could be addressed that could be remedied without vacating a sentence?
Justice Wecht, the answer to your question is that it is only their claim that they are not asking to vacate their sentence. They are. Their claim would necessarily vacate their sentence because their sentence necessarily precludes eligibility for parole. It is the sentence that precludes that, and if they were then given eligibility for parole, that would contradict the sentence. So our argument about the PCRA is that sentencing challenges, if they could be diverted into Commonwealth Court.
That's circular, because to get there, you need to bootstrap in the very provision of the parole code that they're challenging.
No, Your Honor, it's exactly the opposite. Their argument is circular. Ours isn't, because this court has repeatedly held that the crimes code in and of itself precludes parole eligibility. And that is consistent with the overall structure of Pennsylvania law, by the way, that it is that the date of parole eligibility is a part of the sentence, not a matter for the parole board. The parole board's power begins under subsection A3 only at the moment after the minimum is reached. Until that point, the parole board has no power. And so it is the sentence set by the trial court that can invest the parole board with power. And therefore, what the defendants are asking for is indeed a challenge to their sentence. And if it could be avoided by going to Commonwealth Court, then all manner of other challenges to sentence could also go there. And that is the problem. This court said clearly in Moore that a challenge to the authority of a court to impose a particular kind of sentence, an overall challenge, the challenge to the authority of any court, constitutional or whatever, is a challenge to the legality of the sentence. The PCRA couldn't be clearer that it is therefore the sole means available and not Commonwealth Court. Thank you very much.
Thank you very much. Well argued, both sides. Interesting case. Let's let the courtroom clear out, Bry.
those. Yeah.
Commonwealth of Pennsylvania versus Derek Gallaway. Representing Mr. Gallaway is Mr. James Baker. Representing the Commonwealth is Mr. Michael Sprague.
In this case, Derek Gallaway was convicted of first-degree murder, robbery, and related offenses in connection with a motel shooting. During the trial, the Commonwealth, over Galloway's objection, was permitted to play a video interview for the jury that showed Gallaway dressed in identifiable Allegheny County prison garb while being interviewed by the detectives at the police station. The Superior Court affirmed the admission of this video evidence, finding that the video's probative value outweighed the prejudice to Gallaway. He appeals, arguing that the Superior Court decision conflicts with this court's and the United States Supreme Court's holdings that an accused right to a fair trial is deprived when he's compelled to appear before a jury in prison garb. He also argues that there was a more pedantic error, that prejudice outweighed the probative value, and desires a new trial. So again, Mr. Baker, if that gets it, go ahead and explain to us why your client should prevail.
Yes, Chief Justice, and good morning, Your Honors. My name is James Baker. I was formerly with the Allegheny County Public Defender's Office, but I'm now with the law firm of Sykoff and Love. My client, Derek Gallaway, was deprived of a fair trial the moment the Commonwealth was allowed to present him in prison garb to the jury. This visual is deeply prejudicial to the right to a fair trial. It breaches the veil of innocence that is so crucial to a trial based in law and proof and fact. Case law tells us of the severe prejudice that this evidence causes to the fact finder, being able to interpret the evidence of the defendant's incarceration in whichever way they so choose. But precedent also speaks to the damaging impact it has on the defendant's credibility and their ability to testify credibly to the jury. The U.S. Supreme Court in Estelle laid out the framework for analyzing these sorts of cases. That framework asks for close scrutiny of this issue, precisely because of the damage they could have on the most fundamental aspect of a trial, the presumption of innocence. It asks us to first analyze the risks that this could prejudice the fact finder. It then asks the court to scrutinize the essential interest that the prosecution has in presenting this evidence, and then to explore viable alternatives. The prejudice here could have been easily avoided, either by questioning the detectives to elicit the defendant's statements as admissible hearsay, using the transcripts that were admitted and presented to the jury, or by using the audio.
Mr. Baker, let's talk about what actually did happen. Your client was shown on a videotape in the prison garb, correct?
Yes, Your Honor.
He was also in the courtroom live in street clothes, not prison garb, through much of the trial. Does it matter that the jury saw him on a videotape rather than in person in the prison garb? Is there any difference? They never saw him in prison clothes in person in the courtroom. Does that matter?
Yes, Your Honor. If a picture is worth 1,000 words, then this video speaks volumes. The jury would no doubt take acknowledgement of the defendant's condition implicit in viewing him in prison garb. And to the extent that the defendant was present in the court in civilian clothing, the dropping of that would make the jury believe that it was a facade. I believe that the jury would see the defendant in civilian clothing at trial as breaking away the illusion of the presumption of innocence.
Let's pursue that. we're talking prejudice. Prejudice is an objective standard of a reasonable person. We've all participated in criminal jury trials, I believe. I, as both prosecutor and defense attorney. During the voir dire, we specifically request any potential jury individuals, whether they know or whether they themselves were arrested, whether they know or whether they themselves were a victim of crimes. Inherent in an arrest is the detention and placement of an individual in a police facility, and or everybody is well aware just by watching TV that unfortunately socioeconomics causes incarceration for a period of time, not innocence, poverty. How are we to follow your argument or give your argument credence when in fact the entire trial he was in plain clothes, which is quite distinguishable from Scopa's, from our case law as well as Estelle. And in this particular case, I believe it was a 2.5 day trial. Yet the excerpt of the video shown was only 17 minutes. Tell me how you overcome the prejudice hurdle when we are selecting a jury of our peers who are quite well aware of the criminal process, which includes detention.
So, Justice Doherty, I don't know that I would agree that an arrest always leads to detention. An individual may be arrested at the scene of the crime and then released, and it also doesn't mean that the person was incarcerated throughout the entirety of the pretrial proceedings. As much as we as lawyers and experienced jurists having experience in criminal matters might be able to understand all of these, I don't know that we can assume that for a jury. The jury is not instructed on the fact that pretrial incarceration is not meant to be any interpretation of the evidence of guilt. They're not instructed in these deeper issues.
Wait, but the offer was made to instruct them. The trial judge here made the offer to issue an instruction to the jury, and that was declined.
Yes, Your Honor. And I would note first that this court has issued a recent decision in Commonwealth v. Fitzgerald, I believe that it was, that a limiting instruction does not make inadmissible evidence admissible. And to the extent that a limiting instruction could have been given here, this is deeply prejudicial evidence. As Commonwealth v. Cruz stated, this is the kind of evidence that a jury may not be able to disregard from its judgment, even with the best of cautionary instructions.
I guess my question though is, and that's like the second time you've gone to this. It's deeply prejudicial, and I think Justice Doherty asked a very straightforward question, which is why? Why is it he was arrested for murder and robbery, and it seems to me, and you tell me that I'm wrong, that the average reasonable person selected for a jury for someone who is charged with murder and robbery, seeing them at some point in time in prison garb during interrogation, wouldn't be that shocked to see them in prison garb at some point in time, particularly if they're sitting in the courtroom, though, in civvies. So why is it deeply prejudicial? Because
the jury seeing the defendant in prison clothing it forms the constant reminder of their incarcerated state. Someone being incarcerated is not evidence of guilt, but it creates the association that they are somehow...
That's what I'm trying to understand, is you're saying this in such a conclusory fashion. Is there some precedent that you can cite to, and I've read the precedent that you've cited, that showing a defendant who is in the courtroom, not in prison garb, on trial and presumed innocent, for a video of them while they're being interrogated and we're in detention is deeply prejudicial. That's what I'm trying to understand, because again, I'm, as a human being, and maybe my legal training does influence how I see this, but I can't believe that it would be so shocking for a jury in a criminal trial to see, yeah, he was in prison garb, he was charged with murder and robbery. It's not, ridiculous to think that at some point in time he was in prison garb.
Well, Your Honor, to that I would start with the full Superior Court decision in Keeler that said that severe prejudice inures whenever the defendant is portrayed in this way, and that in no circumstance should that have occurred, because the court goes through the different ways in which this prejudices the defendant, that it's not that the jury will take this evidence that is not evidence of guilt or innocence and will make assumptions whether the defendant has an extra level of dangerousness that justified their incarceration, whether there had already been some sort of prior determination of guilt.
Is that based on anything? Is that just judges saying we just believe that, or is it based on expert testimony? People who understand how juries react. That's what I'm trying to understand, because how can we make such a broad conclusion that, if you see a defendant in prison garb in a video for 30 seconds, or three seconds for that matter, it's automatically prejudicial and they have to have a new trial?
Well, Your Honor, there has not been any expert testimony in this case or any prior cases that I've known about. But this has been a rule that has been in place since the common law of Britain was established. Cruz cited to a case, I believe it was Cruz that cited to a case from 1687, saying that the defendant should not appear before the jury in implements of incarceration.
It goes back to Coke and Blackstone, doesn't it?
It goes
Maybe
back.
Justice Brobson's quarrel is with them. Let me ask you a different question.
I don't know them very well.
Well,
You can be forgiven.
I've read about them. Isn't it an additional layer here that the very questions about prejudice and the weighing of that my colleagues have been asking you about was not performed one way or another in any way by the trial judge. And it's that complete absence of work by the trial judge to assess that question that puts this case in such a problematic light. So we're not here reviewing the trial judge's exercise of discretion. Rather, we're reviewing a case where the trial judge utterly failed to do any weighing at all. Isn't that where we are here?
Your Honor, I would agree with that assessment to the that this framework that has been created by Estelle in subsequent cases sets the grounds for how these sorts of cases should be analyzed and reviewed. And the trial court here engaged in none of that reasoning. This is not mundane evidence that should come in every trial. But
What about the request to instruct the jury? Isn't that the trial court correcting the error that was not within its control?
Well, again,
And that was refused by the defense.
it was, Your Honor. And again, I would point back to this honorable court's decision in Fitzgerald that a limiting instruction does not make inadmissible evidence admissible. What it does is that if the probative value of the evidence can overcome the prejudice, but there's still severe prejudice, the limiting instruction can reduce the effect of that prejudice, but it does not make the evidence admissible in that case. That no limiting instruction could have saved the risks of prejudice here. And this honorable court, to my knowledge, this body has not issued a decision that has gone into the prejudices. But the United States Supreme Court in Estelle was unanimous in how it addressed the problems of this evidence, and that this...
Now, I'm sorry, go ahead and finish your statement.
And that this evidence is unnecessary to a trial. The Commonwealth talks about how it wanted this evidence for consciousness of guilt.
Before you go forward, because you've gone back to Estelle about 6 times, and I let it go the first 5. In Estelle, the defendant was in his prison garb, I believe, for the entire trial. And the Supreme Court's opinion, and I noticed it because I was thinking about variations on this theme, said compelling an accuser to appear at trial in prison clothing creates an unacceptable risk of impairing the presumption of innocence because of the, quote, constant reminder of the accused's incarcerated status. So this is not, and I'm not saying you don't prevail, but this is not Estelle. This is sort of the next case down. It's also not Keeler, where he appeared live before the jury pool for 35 minutes. Here we have 17 minutes out of a 3-day trial on videotape.
On the 3rd day of trial.
on the third day of trial, on videotape for 17 minutes. So if this was Estelle, maybe Keeler, although it's a Superior Court case not binding on us, it'd be an easier case. This is a probative versus prejudicial weighing. And I agree with Justice Weck, there's not much on the record. The trial court did presumably weigh it and exercise his discretion because he let it in instead of just, as you said, playing the audio. But this is neither of those cases. We're going further and further, and you don't propose a rule that if somehow, by happenstance, a juror sees a defendant in prison garb, that's like the mention of insurance in the old days. That's an automatic mistrial.
No, Your Honor, I'm not asking for a per se rule.
So maybe you can briefly tell us, therefore. I think what we've established here is the prejudice is not so manifest as to require a new trial. The question is to weigh the prejudice and the probative value. The probative value of it seemed pretty compelling. It caught him in 5 separate lies, which certainly impacts his credibility, even if it's audio only. So why doesn't the prejudicial value, while real, yield to the probative value?
Right, Your Honor, and I think that there are 2 questions implicit there, so I'll try to start answering the first. That at its core, the error here is the jury, the fact finder, being introduced to the fact of the defendant's incarceration in such a visceral manner that the constant reminder of the defendant's carceral status is not created only where the defendant is present in front of them throughout the entire trial in prison clothing. This video evidence, which in our modern age is how we appreciate media, it's how we appreciate, anyone in my generation seeing a video isn't going to think less of it because it's not in person. The problem is that as soon as the video has played long enough for the jury to be able to identify the defendant in prison garb, I would say anything longer than a TikTok video would not fail to be understood by the jury.
So to interrupt you, though, you really are looking, and this is fine, you're looking for a rule if a jury sees a defendant in prison garb, that's a mistrial and we have to begin again. If, for instance, the judge said, play the audio, not the video, and they flip it on and somehow for a technical reason, the video shows for the first 3 seconds before it cuts off to the audio to be played, you would be here arguing for a new trial.
Well, Your Honor, I would still be arguing for a new trial, but as a matter of just general legal understanding, that there would be more of an argument there that the jury would not have been apprised of that a 3-second blip on a video screen when they're paying attention to the audio may not have infected the jury's fact-finding decision because they may not have taken notice of it. So it would be a much closer situation, but I would still take issue with multiple minutes of a video being displayed where they're constantly being, this is what they're concentrating on.
And the point, again, the point here isn't the point here that instead of us sitting up here and trying to fly spec this thing now, we rely on the trial judges to do this balancing and not just make a flippant remark. We see these guys in prison reds all the time. It happens all the time, right? So that we require the trial judges, pursuant to Estelle and Deck and all these other cases, including the Deal case in Kentucky, the trial judges have to do this work, right?
Yes,
Rather than
Your
us
Honor.
sitting up here trying to figure out is 17 minutes too much or is a passing glimpse too much, right? This is the problem, right?
Yes, Your Honor, and I would be advocating for a standard that is clear enough so that we don't have to be guessing about this, that the trial court should have to engage in this analysis because, again, we cannot reduce this to a mundane piece of evidence. If, as Justice Dougherty was asking with his question, if an arrest is enough to present the defendant in prison garb on a video, if it's not surprising for a defendant to be shown in prison, then what is the rule in Estelle?
You don't want a prejudice versus probative analysis at all. You want a per se rule that at some prescribed period of exposure, you have a fatal error in new trial. And I think I interrupted Justice Mundy.
I was just going to say, if we were going to,
No, go ahead.
if we were going to take that path and make a consideration, would our consideration start back in the interview room when your client consented to the interview? Correct?
Your Honor,
And he knew it was going to be videotaped?
there's
And he didn't ask for a change of clothes for the video?
right, Your Honor. So the
Would that be
defendant,
part of the consideration?
I think it's hard for me to say at this point that that should necessarily be decided because the Miranda.
Well, if you're, I'm sorry to cut you off, but
go ahead.
the hands-on application of what you're asking for today puts our police departments across this Commonwealth, before they take any type of statement from any type of criminal defendant, to say, wait a minute, let's take you in here and let's put on a plainclothes outfit so that we can proceed with an interview. And I think that's really, especially in this situation where your client was not brought live into the courtroom in prison garb. That's my concern.
No, Your Honor, and I do understand the concern. I would just note that the error here relies on how the fact finder will view this evidence. So the police would be free to interview the defendant here, as they did. They would be free to introduce the audio of it. But just if the video is that important to them, I think that that is a due process protection that they should be aware of. But I don't think that it really impacts the kind of error that occurred here, because it is the jury, it is the fact finder that is the basis for whether there was prejudice here or not.
Counsel, can you answer Justice Mundy's response or question as to how should we consider the defendant's consent in our analysis of prejudice?
In this particular case, Your Honor, I do not believe that the defendant's consent based on Miranda warnings that do not include waiving the right to be presented at a jury trial in civilian clothing has any impact on this case. It may be a different situation if police start including that in Miranda warnings, but in this case, the defendant was brought to the detectives to speak with them. He agreed to speak with them to answer their questions. Those
And be videoed, correct?
Yes.
Is it your claim that the video was done without your client's permission and consent?
Not at all, Your Honor.
So, again, your client permitted and consented to be videotaped knowing its introduction in a criminal case. Thus why the Miranda warnings say anything you say can and will be used against you in a court of law. So in your prejudice analysis, do we consider the defendant's intelligent waiver and consent to be videotaped for its introduction into evidence in a criminal trial, which separates and distinguishes this case significantly from Keeler and Estelle?
I have some serious issues with allowing that to be a controlling factor in a case like this, because a defendant without the advice of counsel would be waiving a significant right in these sorts of cases.
That's the beauty of Miranda, or the disease of Miranda, that you have that intellectual right. There is a belief that an individual is quite intelligent and knowingly waiving their constitutional rights, subjecting them to exactly what transpired.
Well, Your Honor, let's assume for a minute that I'm correct, that this portrayal of the defendant in prison clothing will go to the very heart of a trial, the presumption of innocence. If that is the case, we are talking about the waiver of the defendant's fair trial based on a one-sentence question that the police ask before they've had a chance to speak with counsel, and the jury would not be apprised of any of this. The impact on them doesn't matter. If Your Honor is talking about some sort of a waiver rule here, sort of as Estelle...
I'm asking you, how are we to take into consideration in our analysis of prejudice the defendant's consent? we're not even addressing the trial issues because the corrective measure would have been a curative instruction, which was denied. I'm just asking you from the get-go, in our analysis of prejudice, how shall we consider, or what weight shall we consider a defendant's consent? If at all. Is it your position we don't?
Without being able to think about it more, I would say it should not be considered based on the risks that this sort of evidence
Thank you.
creates. And
Justice Todd has a final question.
yes,
Mr. Baker, when you were with the Public Defender's Office, did you have the opportunity to argue before this court?
no, Your Honor, I did not. This is my first argument before this body.
I thought it
case
might
before
be,
this
and I
body.
wanted to welcome you to the court and tell you what a great job you did.
Thank you, Your Honor. And it sounds like there may be no further questions. So,
Counsel, really, you did an excellent job, and it's really a tribute to your new employer that you're being allowed to continue with this on a pro bono basis.
I would agree, Your Honor, and I'm very thankful to Attorney Sykov-Gross, who is staring daggers behind me right now. But my client's argument is at an end. But I would implore this honorable court's attention for just 1 or 2 minutes more. The way
Imagine what's not been said. Why don't you take 30 seconds? I mean, if you really have something new, that's wonderful, but it seems to me that we've beaten this horse to death.
I understand, Your Honor, but if you would give me 30 seconds.
Go ahead.
I've been disturbed by the treatment of this case, both by the trial court's reasoning here and failure to follow basic protections that should be here, and also by the Superior Court's reasoning that I've laid out more fully in my briefing. Not 2 weeks ago, the Superior Court, in the decision of Commonwealth versus Wilson, decided to affirm the use of a prison visitation log for strikingly similar reasons that were used here. This is not an isolated problem that courts are not considering the severe prejudice that this sort of evidence entails. This honorable court sets the tone for how we talk about the law and how we think about the law. And I think it's past time that this honorable court weighed in on exactly the kinds of prejudice that this evidence creates. And that if my client's cause on appeal is just and correct and a new trial is warranted, I would ask that a decision be rendered in the strongest of terms.
Thank you.
Thank you.
Thank you,
Appreciate it.
counsel.
Mr. Striley?
Your Honors, may it please the Court, Michael Striley for the Commonwealth. Your Honors, my colleague Paul Scholey.
Been here before, Mr. Striley.
Your Honor, in fact, if I may say, this is probably my last appearance. This is the 90th case I've argued in front of the court, and I plan to retire, much like my colleague Paul Scholey has done so. So I hope this is, and I want to thank the court for its indulgence over the years. Let me start with one thing, and Justice Doherty, you hit this on the head. If this court is to give Mr. Baker's client relief, it has to basically radically expand Keeler and Estelle v. Williams, and it has to overrule its own precedent. And Justice Weck, I need to address your question. I don't think this court is giving the trial court enough credit as to what it actually considered in this case. It didn't go into a great analysis, but it established two crucial things. Number one, it established that this was going to be relevant and probative evidence. But more importantly, in Keeler, the court says the most important thing about removing the presumption of innocence is that you infer that a defendant, because of jail garb, is in court on in jail on other charges. And Judge Tranquilli offered an instruction, and he ensured that this interview occurred the day that this defendant was extradited from California. And it was not going to infer that there were other charges out there. He made that inquiry. So he inquired as to relevancy, and he inquired as to the most important point in Keeler and Estelle v. Williams. This was a 17-minute video. And I know Mr. Baker says a picture is worth 1,000 words, but I got to tell you, from Zoom in the pandemic, I have realized that real time is a lot different than FaceTime. This defendant walked into the courtroom a free man. He was in civilian clothing. He sat there throughout the entire trial. And I take a difference of opinion as to what Superior Court did. They analyzed this case. They said they dealt with the fact, overwhelming evidence, they dealt with the fact that this jury was informed that he had just been extradited, So he's there, he's not there on other. Yes, sir.
Let me play devil's advocate to your position. If we were to affirm your position, are we in fact supporting the prosecutor's strategic move to introduce evidence at the end of a case knowing it had a prejudicial tinge to it? That being well aware that the defendant was in prison garb, knowing, as astute attorneys of the Commonwealth, that Estelle exists and Keeler exists in the plethora of other cases. Why would it not be introduced just in audio form? Because the issue was to get in the I don't want to use, yeah, I didn't want to use that word.
Okay, the untruthful statements.
The untruthful statements.
I'm
the
sorry.
Contradictions in honesty.
I'm sorry for using that term lie, Your Honor.
But help me get over that hurdle, because to me it seemed in the wait process we should also take into consideration when the Commonwealth chose to introduce this at the tail end, after you seem to have overwhelming evidence without a harmless error analysis. You seem to have introduced overwhelming evidence anyway.
Your Honor, we are here for this court to give guidance and to go. This court really hasn't dealt with this issue. So I am here, much like Mr. Baker, saying give us guidance. But, Your Honor, a court, and I agree, the audio would have been okay in this case. But audio isn't always okay. And I actually, because if the demeanor of the defendant is important, the jury should see the demeanor. And I've watched the video.
Well, the answer's easy. Put them in civilian clothes if that's your trial strategy.
But, Your Honor,
Go ahead and finish Justice Doherty's question. I'm sorry.
my hearing aid went out, Your Honor, when you.
I interrupted you. I apologize.
Oh, no.
Justice Doherty asked you a good question. I think deserves an answer.
So, Your Honor, the audio could have been used, but there are instances where audio isn't enough. And with the instruction, so this court could say to the bench and bar, don't put it at the end of your case. But the thing is, at the end of the case actually helped this defendant, because throughout the whole trial, the jury's seeing him in civilian clothing, and that's the most important part. They're seeing him as an innocent man. This happens at the end of the trial. So it doesn't the other concern with Keeler and Estelle is that it creates a psychological impact on the defendant. It humiliates him. Well, it didn't happen until the end of the trial, so the defendant wasn't humiliated at all, and if he was, it was at the end of the trial.
Can I follow up on that,
Yes.
Mr. Striley? So I think it was in response to, I think my colleague Justice Doherty made an interesting point, is you have a case presumably with overwhelming evidence, so why would you sow error by getting anywhere near the Estelle line? In other words, you're here, you say, for guidance, and isn't it sufficient guidance to say, as is made clear in Estelle and Keeler and Deck in this Deal case from Kentucky, trial courts, we need you to do the weighing analysis. We need you to do the weighing analysis and not just a cavalier statement, quote, this is not the only case where a defendant is interviewed in their jail reds. Don't we require some kind of deliberative process, some kind of thought process from our trial judges so that we, on appeal then, can decide whether they abuse their discretion or not? Because here it seems to me there was no exercise of discretion, but rather simply a cavalier assertion, we see it all the time. That seems to me to be a problem when you look at all the precedents going back to Estelle.
Your Honor, I understand what you're saying, but your question isn't grounded in what happened here. Judge Tranquilli, he made the flippant comment about the jail reds, but he also turned to Mr. Fitzsimmons and made him establish why this was relevant and probative. And then he also turned to Mr. Fitzsimmons and made him assure the court that this was going to be clear, that this interview occurred on the day that this defendant was brought back from California, so it did not imply other charges. And Keeler and Estelle, that's the main factor in Keeler and Estelle. They don't want jail clothes to infer other charges. And Judge Tranquilli asked that of Mr. Fitzsimmons. So he did a flippant comment, but he wasn't a pumpkin. He made inquiries into two of the other factors.
Mr. Striley, can I ask you a wholly distinct question that
Yes.
nobody's asked you? And I may see this case differently than some of my colleagues, which is healthy. The Commonwealth story is that the night before the robbery was discussed, to do this in short form, that he therefore went into the motel office. His DNA is found on the way in, his DNA in blood droplets found on the way out on the cash bag. Ergo, obviously, he did it. He takes the witness stand, somewhat unusual in and of itself in a criminal case. He says, I was out in the parking lot, I was with a prostitute, gunshots start going, I lean down and I get cut on my prostitute's crack pipe. Maybe ludicrous, but maybe not. I obviously, with the gunshot stops, I run into the hotel room, into the motel office, because I wanted to know what happened. Was somebody hurt, etc. I'm bleeding all the way in. I'm bleeding, looking around to see what happened. I'm bleeding out. And then I got out of there because I'm not the most stellar of people, and I didn't want to get involved in all of this. Now, to the extent that that's a he said, she said, that's a plausible explanation, as is the Commonwealth's plausible explanation, and you're weighing prejudicial versus probative value, there's an argument that showing him in his jail garb tips this to be prejudicial, as the jury has to say, do we believe his version or the Commonwealth's version? Now, there is more evidence, the fact that you caught him in lies, which was the audio portion of this. But it seems to me that this may have been a reasonable doubt case, and therefore I ponder whether or not the jail garb vision tipped that to the Commonwealth. And therefore they would be correct on a different theory than Mr. Baker argued. Not that when you see somebody in jail garb, you get a new trial, but that here there really is some prejudice.
Well, my main response to that, Mr. Chief Justice, is that when the video's played, but when the defendant takes the stand, he's in front of the jury with a suit and tie on. He's dressed as a free individual. So they're seeing that free man in the witness stand. So there's a juxtaposition of factors going on here. There's the interview that happened earlier, but he's right there in front of them with a suit and tie on.
So you would say probative outweighs prejudicial, even assuming there's some prejudice on this side of the scale?
Yes.
Well, then, if that's your position, counsel, wouldn't all of these cases from Estelle on down have gone the other way, because the rationale would have been not Estelle, but providing a variation of those facts in Estelle, supposing that there was any moment at which the jury could view the defendant in civilian garb, in freedom, as you say.
Those are the court's words, Your Honor.
Okay. Then that would categorically trump any appearance in jail reds, to use Judge Tranquilli's characterization, no matter how lengthy. In other words, the point is, it seems to me, I think your answer to the Chief Justice suggested, that all that was needed to cure any prejudice in these cases categorically would be any time that the jury had an opportunity to see the defendant in civilian garb, that has cleansed and cured any prejudice that might otherwise inure. Is that your response?
No, that's not my response, Your Honor. My response to the Chief Justice was the fact that if we're going to weigh how it affected credibility, it was important that when the defendant was giving his testimony that he was dressed in civilian clothing. And Estelle, that defendant sat throughout the trial in jail garb. In the other cases, the defendant appeared in front of his jurors during selection in jail garb. There was no real-time viewing of this defendant in jail garb. And my position is that's important given the fact that this is 17 minutes over a 3-day trial.
So I can appreciate the in-person distinction versus, throughout the period of the trial. I can get that. I think Estelle bears that out. I think Keeler bears that out. Is there, under your theory, is there a period of time? The problem with these types of cases, if we get into periods of time, it really becomes very subjective, right? How much time is like nunc-pro-tunc relief? How long do you have to wait before you file?
Yeah, Colorado said an hour and 15-minute interview was okay.
Right, exactly.
Right.
So if we go down that road, it's a fairly dangerous road to go down. But if you were to go down that road, which I think you are actually traveling that highway, if the interview lasted, how long would this be an issue that you would say, yeah, it shouldn't have happened?
I'm going to be very frank with Your Honor. I think that given how we're going with Zoom and all the interviews that goes on, if this court were to say, normally you should just play audio unless the demeanor of the defendant is important, I could see the court doing that. But my point is, harmless error is viable in these types of cases. You got Baker, you got Moore, you got Cox from this case. This court applied harmless error.
How do we know if this was error, how do we know it was harmless?
Because of the overwhelming evidence.
Oh, well, you see, but now you're circling back. In other words, what you said, what you think, and there may be what my colleagues think, what I think, what anybody else thinks. Doesn't this all go to underscore that we don't have any reasoning what the trial judge was thinking, because he failed to give us that deliberative weighing process upon which we rely? Isn't that the problem? Because what we all think now here and what we all suppose, like my colleague Justice Brobson's point about, which I think is a very good one, about these ephemeral considerations, how much time is too much time, right? If the trial judge had given us his reasoned opinion, you know what, this was 17 minutes, here's these circumstances, here's those circumstances, I've weighed it, this is what I think and why, I've wrestled with the precedents, we'd have something to sink our teeth into. We don't have that here. Isn't that a problem in this case?
No, it's not. And Justice Weck, you and I just aren't seeing eye to eye today. And this is the reason. If you go to Keeler says jail garb insinuates that a defendant has been arrested on other charges. And Judge Tranquilli in this case forced the Commonwealth to explain to the court that this defendant was interviewed the day after he was extradited, and the jury was going to be told that.
I think we're covering the same ground again and again. Justice Donahue has a new question.
Counsel, if I might, just sort of probe your view of Estelle, and at least what I view as its predicate holding, which is defendants should not be forced to appear in a courtroom in prison garb because it impairs the presumption of innocence.
And
am I correct?
And it does so by inferring other charges.
I'm not sure that I would read it at all that in that limited fashion. But let me ask you this. I mean, is it the Commonwealth's position that the appearance in prison guard during trial does not impair the presumption of innocence?
Not in all cases, and not under all circumstances.
And why is that? I mean, that's what I'm having a very difficult time grappling with in terms of your
Judge,
position.
I'm a defendant. I cause a ruckus, and they have to shackle me. I'm sitting
But
in
that
shackles.
didn't happen here.
Pardon?
That didn't happen.
No, but that's even extreme in this court. You just asked me if there's ever a situation where someone could be in jail garb and it wouldn't be reversible error. And I just said yes. And and this court has acknowledged that. And more.
Tell me again, what is it in this case that makes it so that the 17-minute appearance in prison garb did not impact the presumption of innocence?
Because throughout the entire trial, he was dressed in civilian garb, and the evidence was overwhelming. This did not affect their decision.
That's just a follow-up. Assume that it is prejudicial to him. Does that end the inquiry, and does he get a new trial, or is there a weighing of prejudice versus probative value?
Your Honor, the harmless error analysis, even if there's a little prejudice, the evidence was overwhelming, and it was
All right,
not.
then last time, because I want to bring this to conclusion, in 15 seconds, if you would.
Yeah.
I explained to you where I saw it as a he said, she said. That his story, well, maybe out there could be accepted by the jury. Cut on the crack pipe. I find it very plausible. He wants to run in to see what happens, so he took his blood with him. So tell me again the facts, just again, A, B, C, in 30 seconds, that makes this an overwhelming case for guilt and therefore any error harmless.
Your Honor, the night of this robbery, he's overheard discussing with Sean Orsini that they were going to do a lick and a robbery that night. That's right there at the hotel. That's heard. We have all his denials of ever having been at the hotel in the past. It's just the overwhelming of his blood. I mean, his blood and the money back.
Maybe it's a good idea when you have such an overwhelming case not to sow error like this.
All right. Thank you,
Like,
Mr.
use the audio, use a detective.
And when the court applies harmless error, hopefully the Commonwealth will come out victorious.
Thank you, Mr. Striley. Thank you both. Mr. Baker, good job.
Thank you, Your Honor.
Brian?
Commonwealth of Pennsylvania versus Nathaniel Ray Price, representing Mr. Price, Mr. David Kaltenbaum, representing Commonwealth, Mr. P. Burns Jr.
This case pertains to cell phone records maintained by Verizon and obtained during the execution of a search warrant. Prior to trial, the defendant filed a motion to suppress the cell phone records because the affidavit supporting the warrant failed to specify that the cell phone number to be searched belonged to the defendant's particular cell phone. The trial court agreed and suppressed the cell phone records. The Superior Court reversed the suppression order on the basis of the doctrine of inevitable discovery. The defendant sought allowance of appeal, asserting that the Commonwealth waived a challenge or a justification of inevitable discovery by failing to put it in its 1925B statement as the appellant. The court granted allowance of appeal to determine whether the Superior Court erred by reversing the suppression on the basis of the doctrine of inevitable discovery. And if that's pretty close, Mr. Kaltenbaugh, please feel free to proceed.
Thank you, Your Honor. And as indicated, to my left is the co-counsel, Thomas K. Hooper of BMZ Law, who is primarily responsible for the death penalty portion of this case against Mr. Price. Going to the argument in this matter, the crux of this matter begins with Rule of Criminal Procedure 203D, the familiar stricture that we're limited to the four corners of the affidavit of probable cause. And that, in going to the four corners, and as the judge in the court below, Judge Bianco, decided, the affidavit of probable cause did not state probable cause. It was because of the omissions in that four-paragraph.
May I ask you,
Yes.
I want to make sure we're all on the same page. There were two affidavits of probable cause in this case, one in 2016 and one in 2017. We're only talking about the 2016 affidavit in this case. Is that right?
That is correct, Your Honor, and
Okay.
I know that looking at the Superior Court opinion, it becomes somewhat misleading
Well,
because...
they got it wrong.
Yeah,
They just got it, it's not just it's just completely wrong.
They used the 2017 affidavit.
Yes.
Mistakes happen.
And can you talk about the Rule 1925B statement?
Yes.
It seems to be the overriding issue in this case, is it not?
Yes. And as to the Rule 1925B statement, and it is limited to the, if you look at it, it goes to the basis that it was decided on. Did the affidavit of probable cause state probable cause? It's our position that it's not, and Judge Bianco agreed with us. And to that effect, I would refer the court to Rule of Appellate Procedure 1925B4V, where it says, and the Superior Court decided it was a subsidiary issue. However, to be a subsidiary issue, it must be, in other words, in this, the subsidiary issue is inevitable discovery, or the independent source doctrine. It must be raised in the lower court. And that, reading that rule, each issue identified in the statement will be deemed to include any subsidiary issue that was raised in the trial court. Here, inevitable discovery, the independent source doctrine, was not raised in the trial court.
Ergo, your position is the Commonwealth Court erred, and what we would have, I'm sorry, the Superior Court erred, and we'd remand, and they would decide the issue of whether or not there was probable cause for the search warrant in the affidavit of search. Is that right?
If,
Do you understand what I asked?
yes, I understand.
Okay.
And again, looking at the Superior Court's opinion, and in their conclusory paragraph, they cite the case of the Pennsylvania Supreme Court case of Commonwealth versus Henderson. And in that case, we had two search warrants. The initial one was found, it did not state probable cause. And however, there were, after the trial court decided it and granted the suppression motion, there was a second suppression motion filed. And in that, there was testimony heard from the affiant in the second one that related the whole basis to show that it was independent. In answer to your question, there would have to be a procedure such as that to be done in the trial court if it was remanded for that purpose.
Counsel, so what you're saying is if we agree with you, we reverse this with the direction to the trial court to determine, without considering inevitable discovery, whether the four corners of the particular warrant has necessary probable cause? Or is that not your argument?
I believe that the four corners of the correct affidavit of probable cause fails to state probable cause.
That's what I'm sharing
Didn't the
with
trial
you.
court, didn't the trial court do that?
Yeah, hasn't the trial court already done that?
Yes.
So then why would the remand be to the trial court?
It'd be the Superior Court.
Be to the Superior Court to evaluate whether the trial court
Yes.
erred in that ruling.
Right.
We would remand to the Superior Court to tell them to answer the question that was presented to them in this appeal.
Yes.
If we
They would
get
be-
there,
the
is there any
Superior
reason-
Court would be looking solely at the affidavit of
Is
probable
there-
cause.
Given that we'd be, in that scenario, we'd be looking simply at the same paper Superior Court would be looking at. If we got there, is there any reason why we wouldn't just make that decision ourselves?
No, Your Honor, I would,
Well, the issue we took was simply, did the Superior Court err in using the inevitable discovery rule for purposes of the ruling that they made, and for essentially reversing the trial court. So we didn't take the rule of whether the affidavit itself, whether probable cause was established for purposes of the warrant or not. But it seems like your case is fairly straightforward. And I don't know how much more time we need to take on it. It's just a waiver. It's a Rule 1925 waiver issue. That's all it is.
and the only
Justice
thing,
Mundy has a question for you. Justice Robson, do you have a question? Did I interrupt you? Yeah, and
think that's what
I
it is.
tend to concur with that. Justice Mundy.
So I understand the argument that you're presenting arising from Rule 203B. No search warrant shall issue but upon probable cause supported by one or more affidavits, plural, sworn before the issuing authority in person.
yes.
In this case, though, it wasn't just one search warrant that was put before this authority. In fact, on October the 27th, there were 3 search warrants presented. One for the search of a black Dodge Dart car that was granted. One that was for the search of the defendant's buccal swab and clothing, which was granted. And one for the search of the defendant's residence, which was granted. And then on the following day, October the 28th, there was a search warrant at issue, which I'm assuming was also presented before the same issuing authority.
At the moment, I couldn't say as to the other ones definitively if they all went before Judge Bianco as they did in this one.
But-
Having been a while since I have visited those particular search warrants, and in all of them, Judge Bianco denied the suppression motions. However, each of those depends on its own affidavit of probable cause.
But what I'm saying is if all of these search warrants went before, boom, 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 all before Judge Bianco, and I understand that there is a deficit with the particular search warrant in question, but how fair is it for this trial judge to say, you have to erase from your mind all those languages of the previous affidavits? And clearly, if this affidavit had contained the same information as the one did for the black Dodge Dart car, the buccal swab and clothing, and the residence of the defendant, it would have met the 4 corners of the affidavit requirement. So aren't we kind of playing a gotcha with Judge Bianco's ruling in that instance?
My response to that, Your Honor, would be that in each of those other 3 search warrants, we were dealing with different property. Their standing questions would be different. And if I'm not mistaken, I believe one of those did go, at least one of them went to a magistrate, but I could be wrong on that.
Mr. Kallenberg, isn't your appropriate answer what Justice Robson said, which is that's the next case when the Superior Court takes a look at the warrant?
Well,
The only question here is inevitable discovery.
Yes.
Well, my point is exactly that. This is Indiana County. How frequently in the history of Indiana County do you get a double homicide in that county? And from looking at the record, these police officers attempted to do the best they could to appropriately investigate this crime, and this had to be a big thing in Indiana County, is my assumption. And so, vis-a-vis the inevitable discovery, it's just my thought that this builds the case for it because there were all these other warrants at the same time. And I can't imagine that you're arguing to this court that 1925B precludes an appellate court from finding the right answer for any right reason.
First of all, as to the any right reason argument, Your Honor, that would go to the fact if the court were to find, and it was raised by the Aplt, the Commonwealth, if the court, and this would be the Superior Court, were to look at that and said, well, the affidavit of probable cause in this case did state probable cause, that would be any right reason. But as going back to the original point, you don't go to the other separate affidavit of probable cause that go to different property, to different issues. You're limited to the one in this case, in this particular search warrant. If you do that, you're going outside of the four corners. You're going to the four corners of other search warrants.
I understand your argument. I just don't
And I'm
agree
sorry.
with it.
Justice Mundy, you done? Yeah, I think so. Okay. Anybody have questions? Thank you very much.
Yes, and as I understand, this is a simple issue, Your Honor.
It's a serious crime, which I think is what concerns Justice Mundy. Mr. Burns.
Good morning, Your Honors. May it please the Court, Hugh Burns of the Commonwealth. The main issue raised by the Commonwealth in the Superior Court was the Suppression Court's error in holding that the warrant failed to establish probable cause because it failed to account for how the police knew the defendant's phone number. That was the specific claim that the defendant raised in the suppression motion, and it is a claim that had nothing to do with probable cause. The phone number is the phone's address. An address in a search warrant goes to the particularity of the place to be searched, not probable cause to search. The defendant did not argue that the phone number was not his, that the phone was not his, that the phone had nothing to do with the murders, or that evidence of the murders was unlikely to be found in his phone.
Mr. Burns, how did the Commonwealth comply in this case with Rule of Appellate Procedure 302A? Quote, issues not raised in the trial court are waived and cannot be raised for the first time on appeal, unquote. And as you can surmise, I'm asking you to tell us specifically where the Commonwealth raised inevitable discovery in the trial court.
In the Commonwealth's March 15th, 2019 brief in opposition to the defendant's omnibus pretrial motion at page 30, Your Honor.
Is there specific reference to the inevitable discovery doctrine there?
Yes. Now, disputing it addressed does not dispute probable cause. If a probable cause affidavit shows that a murder weapon is locked in a safe, for example, we don't need to know the combination of the safe in order to know whether or not there's probable cause. Probable cause is the likelihood that evidence will be found in the safe. The combination is how you get the safe open. They're two different things. The rules of criminal procedure require a suppression claim to be raised with specificity and particularity, and the defendant did that, but the specific claim he raised did not dispute probable cause. The suppression order.
I apologize for interrupting you. I don't see how we get to the question of whether there was probable cause in this case when the only issue that we took was whether the Superior Court erred by relying on inevitable discovery. So I'm not sure why you're not talking about inevitable discovery.
It's the right for any reason doctrine.
Well, but the right for any reason doctrine would apply if the trial court were right for any reason. You sought reversal.
No, the issue is whether or not the Superior Court was wrong. So under the right for any reason doctrine, you can affirm what the Superior Court did if the Superior Court merely gave an incorrect reason for a correct result, and that's what happened here.
So despite the limiting nature of our question on appeal, you want us to also examine the probable cause determination that the Superior Court did not engage in.
That's a limit on the appellant. We're the appellee. You're entitled to affirm the Superior Court under the right for any reason doctrine if what the Superior Court did was correct and it gave an incorrect reason.
Counsel, I believe that you or your office described in your briefing that inevitable discovery was probable cause plus.
Yes.
Therefore, the plus would mean extra. Extra would mean additional pleading. Share with us, in this particular incident, how right for any reason even comes into play with the plus. There is no probable cause, or at least that's what the trial court found. Where did this plus come from other than Superior Court's assumption of that argument?
First, it's, I think, inaccurate to say that the trial court found that there was no probable cause because the narrow issue raised by the defendant in a suppression claim did not dispute probable cause. He disputed something that went to the particularity of the place to be searched, not probable cause. So probable cause as such was not actually before the suppression court. It wasn't before the Superior Court.
That's interesting what you just responded to Justice Dougherty, because it points up the following, that when we see inevitable discovery issues raised in these cases, it seems to me it's invariably in the context of an asserted exception to the exclusionary rule. And I'm not aware of a case where we've ever treated it as an inherent derivative of probable cause. Can you confirm or rebut that?
Inevitable discovery is a variety of harmless error. It comes from the attenuation doctrine. And it would apply in a case like this where there's no police misconduct, the police actually obtained a warrant, and probable cause was effectively undisputed. On those facts, inevitable discovery would follow. And it was raised in the suppression court, and yes, it was omitted from the 1925 statement, but in Commonwealth v. Rogers, this court held that the 1925B statement has to be read in the context of what the party filed in the trial court. It also held in Commonwealth v. LeBoy that, for example, sufficiency of the evidence subsumes vicarious liability. We also cite a decision from the Superior Court en banc, Commonwealth v. McCandless, holding that the law of the case doctrine was an issue, even though it wasn't cited by name, because it was obviously an issue. We also cite a decision of the Supreme Court of Montana, Commonwealth v. Ellis, holding that an appellate court can always raise the inevitable discovery doctrine sua sponte. And all these things support what the Superior Court did. Inevitable discovery certainly applies here, but prior to that, the narrow and specific claim that the defendant raised didn't allow him to dispute probable cause because the claim didn't dispute probable cause. And that was explained. Yes.
I apologize. I'm trying to follow this argument. The October 28th warrant was suppressed. The May 19th warrant was not. The May 19th warrant secured evidence that can be introduced. And my understanding is that the Commonwealth has conceded that the evidence that it would have secured in October 28th was the exact same evidence, or is very similar to the May 19th, such that your prosecution is not substantially hindered or terminated. Am I correct?
No, Your Honor. Our argument was that the judge held incorrectly that the only problem with the warrant was that it failed to explain how the police came by the defendant's cell phone number. First, that's not something that goes to probable cause. It goes to particularity of the place to be searched. But assuming that that was a defect in the warrant, it wasn't, but assuming it was, the story of how the police learned the phone number was in another warrant in the same case that was before the suppression court. The suppression court could look at...
I apologize. For purposes for prosecution, the evidence that you secured in your May 19th warrant, is that similar to the evidence which you would have secured?
No, it's different.
How so? Because I read that record, and I believe, I'm trying to find where in your record you indicated it was the same.
It's not the same. The second warrant went to the contents of the cell phone, whereas the warrant that resulted in the suppression of evidence goes to the phone records that were kept by Verizon. So they're two different things. Ordinarily, you'd expect them to be the same, but I can assure the court that in this particular instance, the records that we actually need are the Verizon records and not the contents of the phone itself. So that's why we're here.
Could you explain how they're different?
Well, it's not in the record, but theoretically, the contents of a phone can be lost if it's not charged, if it's examined incorrectly, whereas the records kept by Verizon are somewhat more permanent, although eventually they erase those too.
Or if somebody deletes the calls.
Yes. Yes. So
Thank you.
Counsel, could you tell me if in the Superior Court you raised the argument that this was not a probable cause issue, but a lack of particularity issue?
we raised the argument that probable cause was not an issue, and that's particularly raised in the reply brief. But
I'm asking you, did you specifically raise the issue that you're arguing to us, that this is not probable cause, it's a lack of particularity?
I don't think we used the phrase lack of particularity in our brief in the Superior Court.
Okay, and let me just follow up on your right for any reason issue. In order for this court to rely on that, does it not have to be an issue that was raised in the intermediate appellate court that it could have relied on in order to come to the same conclusion?
We did raise the argument that probable cause was uncontested under the narrow issue raised by the defendant. So the fact that we didn't specifically note the idea that it goes to particularity instead of probable cause, while true, doesn't mean that the issue wasn't raised in the Superior Court. It was.
Lack of particularity was raised in the Superior Court.
No, the phrase lack of particularity was not raised. What was raised in the Superior Court was that the defendant was not disputing probable cause, that the narrow suppression issue he raised in the suppression court did not dispute probable cause. So saying it went to particularity instead of probable cause is another way of saying that it didn't dispute probable cause.
Superior Court, pick one. Could it be lack of particularity? Could it be something else? I mean,
I'll admit that our argument improved since we were in the Superior Court, but it's not true that it wasn't raised or preserved. Well, thank you for that, Your Honor, but I think...
Counsel, I want to go back to my initial question. I found what I was looking for. I need you to help me flesh out that the evidence that was, that you got from the one warrant wasn't the same as the one that we're discussing. Notably, Detective McComb's testimony from the hearing held November 15, 2017, at page 106, when asked, were they the same, he suggested that, quote-unquote, they were the same contents were recovered from the two search warrants. So is that correct or not? It appears to see that you're contradicting what your detective said. The notes of testimony, that being evidence in front of this court, say that the two warrants, as detective said, were the same evidence. But you're sharing with us that they're not. And that goes to my understanding of how this case is to play out here.
It's very clear from the record that the later warrant went to the contents of the phone itself, the physical phone. The former warrant, the one that's an issue here, went to the records kept by Verizon of the contents of the phone, of the various messages that were sent. Okay? Now, it's not in the record, but it so happens that it is possible for the records kept by the service provider to differ from the contents of the phone if something was erased on the phone.
But I'm just sharing with you, your detective said they were the same. So we have to assume that the record means they're the same. So should we side with the defense's position? It's not hindering or terminating the Commonwealth's prosecution of this defendant based upon the introduction of the evidence that is secured by the May 19th warrant. Is that correct, yes or no?
I don't think it is correct. I do know that it isn't the subject of the Alicotter grant, and it's never been raised before in this case. So no one's ever disputed that we validly certified the case for appeal and that the evidence is important to our case.
Nor did the 1925B statement indicate that inevitable discovery was before this issue, but yet it is.
And you've explained why it is.
Yes.
Well, in that regard, could I go back to the waiver point then and ask you, could you give us your definition of subsidiary issue?
I would use the definition from Commonwealth versus LaBoy. It's an issue that's subsumed in the issue that's being raised. However, I would also raise Commonwealth versus Rogers, which said that the motion.
I think we're almost done, and I think we've never given you a fair opportunity to, and we try at the beginning to give people a couple minutes to state their thesis. So, in conclusion, if you wanted to take 1 minute and we won't interrupt you, and you tell us why you should prevail, I'd allow you to do that.
Well, I won't need that long, Your Honor. The state police did nothing wrong. They did nothing wrong here. They got a warrant. They got a warrant with probable cause. Probable cause is not disputed. There was no police misconduct. It seems to me that there are two valid options. One is to remand at the Superior Court for them to rule on the issue that the Commonwealth did preserve, that the argument raised in the suppression court didn't go to probable cause, or the one that is most conserving of judicial resources is to affirm the Superior Court under the right for any reason doctrine, assuming they got the waiver question wrong, which I would submit they did not.
Thank you very much.
Thank you, Your Honors.
I think that's helpful. Thank you.
McGuire versus the City of Pittsburgh, representing McGuire, Ms. Margaret Coleman, representing the city, Ms. Julie Korn.
An off-duty city police officer arrived home with his family, found Aplt and his friends vandalizing the police officer's home. The officer chased the Aplt, knocked him down, and punched him in the face, injuring him. Aplt filed a 1983 lawsuit in federal court. A jury found in favor of the appellant, in doing specifically determined that the off-duty police officer was acting under the color of state law. The officer assigned to the appellant his right to seek indemnification from the city under the Political Subdivision Tort Claims Act. The city defended that the officer was not within the scope of his duties. In pursuing indemnification, the question was whether the officer was, as a matter of law, within the scope of his duties because he was acting under color of state law. That went to a jury trial, and the jury concluded that the officer was not within the scope of his duties. The victim has now taken an appeal to us to examine whether under color of state law subsumes within the scope of his duties, and collateral estoppel would apply to compel the city to indemnify the officer for the federal verdict. So somewhat complicated, but I think that's it. Ms. Coleman?
Yes, thank you, Your Honor. This case presents the question of whether a municipality should be required to take financial responsibility for its police officers when they act under color of law.
Ms. Coleman, you should introduce your co-counsel.
Oh, I apologize, Tim O'Brien.
Thank you.
Sorry for that.
And let me admonish my colleagues, we want to give you a couple minutes to state your premise, especially in this complicated case. So we'll do that, and then we'll begin to torture you.
Okay. Thank you. I look forward to it. Closer? Absolutely. Okay. So this court has repeatedly held that the purpose of the indemnification statute is to allow municipal employees to perform their duties without the fear of personal liability. The indemnification statute of the PSTCA also provides a remedy to plaintiffs whose rights are violated by municipal police officers who are using their official authority. The Commonwealth Court's decision harms municipal employees by exposing them to personal liability when they are acting in their official capacities. And it also harms injured plaintiffs because it denies them a remedy to which they are legally entitled. The Commonwealth Court's opinion, therefore, is at odds with both the language and the goals of the indemnification statute, and our position is that it should be overturned. There are two primary ways in which we believe that the Commonwealth Court erred. The first was in permitting a jury trial to happen under the indemnification statute at all. We believe that the indemnification statute, by its terms, requires that the criteria for indemnification be determined in the initial damages action. So in this case, the criteria for indemnification needed to be determined in the federal court damages action. They were determined in that action. There was no need to have a second jury trial, and it was not permissible to have a second jury trial and subject both plaintiff and the officer who punched him to that, an entirely new, duplicative, and very burdensome and expensive judicial proceeding just to determine his indemnification rights. As I said, the statute specifically...
We've covered about 2 minutes, so anybody that has questions, feel free to interrupt. Ms. Kuhlman?
Well, thanks, Chief. Understanding the 1983 construct and how it works, all you have to do is prove acting within color of state law. It seems to me that the issue in this case is whether acting within the course or scope of official office or duties, I think is the language we're dealing with here. Because, of course, the General Assembly uses different language when they probably mean the same thing, but they should try to be consistent, is the same thing as color of law. And if it isn't, then that issue would never be decided by a court handling a 1983 action, because there would be no reason to ask for a special jury interrogatory on course and scope, because all you need is color of law. Where am I wrong?
Right. So I do not agree. I think that this scope of office, for reasons that we will get into, is exactly the same thing as acting under a color of state law. But even if the court were to determine that it was not exactly the same thing, I think that the city would have an opportunity to intervene in the federal action if they believed if they intended to deny indemnification and they wanted a determination that the officer was acting outside of the scope of his office, they could request that determination in the federal court.
Yeah, but they don't have to intervene. That's what I'm saying. I mean, you're basically saying then, well, it's the obligation of the city to litigate its indemnification obligation within the context of a 1983 action. And you're suggesting that we're going to issue a rule of law that says, oh, by the way, if you're ever going to contest indemnification in 1983 cases, you, municipality, have an obligation to intervene.
Yes, I would suggest that that's exactly what the statute says. The statute says when there is an action for damages brought, and it is determined that the officer was acting in the course and scope of his duties, and then, so that's the indemnification portion, then the willful misconduct portion of the statute is even more clear, because it says specifically...
Well, you're reading the indemnification, I'm familiar with the indemnification statute. I understand how you're reading it, but you didn't answer my basic question, which is, if it's just me suing a government official under a 1983 action, I don't have to prove that the government official was acting under color of state law. I only have to prove that they were acting under color of state law. I do not have to prove that they were acting in the course and scope of their employment. As a plaintiff's counsel in a 1983 action, I would never want that burden. I would only want to show that this person was acting under color of state law. You're suggesting that in every 1983 action, we now have to have this additional proof element in order for the police officer to be indemnified. And that's not really how I read the Commonwealth Court's opinion in Pender.
So that is not exactly not what we are saying. What we are saying is that the term, first of all, we're saying that the whole phrase scope of employment and how that has been interpreted in the restatement and by this court in justice has absolutely no application whatsoever to the indemnification statute. So so there would be no need in a Section 1983 action to determine the scope of employment question. What needs to be determined in the 1983 action is whether or not the person was acting under color of law, and then when you take that color of law determination and apply it to the indemnification statute, that automatically, that means the same thing as the person was acting within the scope of their office.
Well, but follow up on that one. So you're indicating that a federal jury's determination of under color of state law is equated to the Pennsylvania's under scope of employment and duties. Is that what you're saying?
So the phrase is under scope of, or within the scope of office or duties.
Office and duties. Yes. Is that what you're saying, that it's one and the same?
Yes, I am saying that. And
Now, what if, when you look at that, let's look at the practical application. If there are two different jury trial instructions, one in the federal court and one in the Pennsylvania court, does that change the analysis as to whether they're equal or the same?
I don't think there should be, well, our position is there should never be another set of jury instructions, that there's only one set of jury instructions. It's the instructions on the color of law question in federal court. And then when you get to state court, you don't get to relitigate that issue in a separate indemnification trial. And I'd point the court to the Commonwealth Court's opinion in Tepper.
But
where they held
willful
exactly that.
misconduct is essential in indemnification, yet it's not essential in a 1983 action. Wouldn't that be determined as a matter of fact for a jury to decide?
That is something that, under the terms of the statute, needs to be determined in the federal action. And that is the reason why the statute requires that the city be given notice of the initial damages action.
But that would be an amendment to 1983 action, not our indemnification Pennsylvania statute.
I'm sorry, I'm not sure I understand.
Yeah, I'm not following your argument, so repeat it.
So if the statute requires that the city be given notice of the underlying damages action, in this case, it's the 1983 action. The reason under this court's opinion, the Commonwealth Court's opinion in Rettenauer versus Flaherty, the reason for that notice provision is so that the city can intervene in the damages action if it wants to, and to protect its interests. So the city had the opportunity here to intervene, and they did participate in the litigation.
Yeah, but it's to protect their interest on the amount of the damages award. And look, I read the statute multiple times, and I can completely understand why you are reading it to mean that in order for the indemnification provision to be triggered, that the acting within the course and scope of officer duties is something that's determined in the original damages action. That was Justice versus Lombardo, which was not a federal action, that was a state court action, and it makes a whole lot of sense there. But it doesn't make sense in a 1983 action, because in a 1983 action, again, which I don't think you've responded to, course and scope is irrelevant to the plaintiff prevailing on their case. And it would never be determined in a 1983 action unless, as you're saying, a municipality would voluntarily intervene and try to litigate the indemnification provision in the federal courts. And I'm not sure all federal courts would allow that to happen. I'm not sure all plaintiffs would want that to happen. I'm not sure all defendants would want that to happen, because if a jury in federal court knows that there's an indemnification provision available, that might influence the outcome of the case. So I think you've hit a point about the interpretation of the statute, but the problem is, if it's your interpretation, the indemnification clause would never be triggered in a 1983 damages case.
I don't believe that's true, because our position is that the finding of under color of law is absolutely essential in every
Well, that's your
single
best argument. Your best argument, to Justice Dougherty's point, is if we equate a federal jury's determination of under color of law as acting within course and scope of officer duties, game over. I think that's your best argument. Mm-hmm. I think the problem you have there is a situation like this, or a worse situation. A police officer who exercises his or her office in an egregious way in extreme brutality could be found liable under 1983 for damages because he or she acted under color of law, but would not likely be found to be acting within the course or scope of officer duties, at least under prevailing Pennsylvania law.
I think that the indemnification statute provides for exactly that circumstance in the willful misconduct provision. So the phrase, right, so if an officer did what you are suggesting and behaved in that way, then that would be willful misconduct. And if it was willful misconduct, then there would be no indemnification. Under the restatement.
But how does that get into, your problem is that would not get decided in a 1983 action.
I think it could get decided.
I agree with you. I think it could, but that's a different question from when a strategic litigation decision is made not to intervene when you permissibly can, whether a municipality forfeits any right of indemnification just because a federal jury found that the employee acted under color of law.
Well, because the statute requires that the willful misconduct determination be made in the federal action, then the Federal Rules of Civil Procedure would give the city an automatic right to intervene in that action to protect its interest. At that time, under the Rettenauer versus Flaherty case, they could present witnesses, they could present argument, they could do any number of things to protect themselves.
One more question, because I've been monopolizing your time. I apologize, but Commonwealth Court stuff really interests me. You represented actually the plaintiff in the federal suit, correct?
Another law firm did, but yes.
Another law firm, but you're essentially standing in the assignment. Knowing that the indemnification statute was available, did your then client or the other law firm's client actually ask a jury instruction on this very issue, course or scope, and willful misconduct, such that you could get these findings from the federal jury available to you when and if this assignment happened, and you could pursue indemnification?
So did the plaintiff, are you asking, ask for that, or did the defendant ask? No, the plaintiff did not ask for that. Well, but what the plaintiff asked for was a determination that he was acting under color of law.
You would need that for a liability.
Exactly, and that, if the court accepts our argument as to statutory interpretation, that was the equivalent of a finding that he was acting within the course and scope of his, within the scope of his office under the indemnification statute. And so there would be no need for the other jury trial.
Counsel, a couple of things. The first is actually a factual question, so this doesn't count as a question.
You can have as many as you like.
Was Officer Nedick tendered a defense by the city in the 1983 action?
So the city was named as a defendant? I understand.
I'm asking you whether or not the city of Pittsburgh paid for the defense of Officer Nedig in the 1983 action.
The city of Pittsburgh did. The city of Pittsburgh appointed Paul Krebs and his firm to represent Nedig during the damages trial.
Okay.
Yes.
Put that aside for a moment. You and I have a fundamental disagreement about what the statute says. And I think I might have a fundamental disagreement with my colleague, Justice Brobson, on this. The indemnification statute uses the phrase within the scope of his office or disjunctively duties. Every single case that this court has decided has interpreted the phrase scope of his duties. We have never addressed the issue of what, in fact, the legislature meant by scope of office. Do you agree with me?
I absolutely agree with you on that.
That's not what you said. You said it's scope of officer duties, and you use them as though they mean the same thing. And I'm asking you, do you think that means the same thing, scope of office versus scope of duties?
I do not. I believe that the legislature included the word office. I mean, it can't be mere surplusage. It has to mean something, and it makes sense in the context of the indemnification statute to assume that scope of office means the same thing as under color of law, because when you act under color of law, you are acting in your official capacity. You're using the powers of your office to commit whatever act.
Okay, and so far we're on the same page. Let me give you the Justice versus Lombardi fact situation. We determined, reversing the Commonwealth Court, that the state trooper in that case was not acting within the scope of his duties.
Correct.
But he was, in fact, acting within the scope of his office, was he not?
He was, in fact, doing that. He was acting in the scope of his office. If you took those same facts and you applied them to the indemnification statute, Justice Lombardi would have been indemnified. And I think that
he was acting within the scope of his office, regardless of the fact that he was acting outside of the scope of his duties under the scenario in which we found him.
exactly, Your Honor.
Now, in the federal jury charge in this case, one of the factors that the jury was asked to decide or was asked to consider was whether or not he was acting under the scope of law because he arrested an individual. Would that be within scope of authority of a police officer to make an arrest?
Absolutely.
Okay, so your argument is then maybe that color of law equates with scope of office in terms of the indemnification provision under the Political Subdivision Tort Claims Act.
Absolutely. Scope of office, as I said before, the Commonwealth or the legislature included that word office. If the statute under which Justice versus Lombardi was decided was the immunity statute.
I understand.
So the language is different in the immunity statute.
Tough argument if you're going down a path that scope of duties, as this court and the Commonwealth Court has repeatedly defined it, is the equivalent of color of law.
And that is absolutely not our argument. Our argument is that.
Sorry, what you said earlier, and that's why I keep stressing this point, because I mean, all of our cases, and I think my staff and I did an exhaustive search of the cases dealing with this issue. They all deal with the phrase scope of duties. None to date have dealt with the interpretation of what scope of office entails.
That is absolutely true. And if I misspoke earlier, I apologize. But we are focused on the word office because the only case that has interpreted a statute even similar to this that uses that phrase office is the Commonwealth Court's decision in the Tepper case. And in that case, the Commonwealth Court did find that the term in office or employment meant the same thing as acting under color of law.
Well, Tepper is completely distinguishable. He was in uniform, flashed a badge. There's no question he was acting as a police officer. He wasn't at home at night in civilian clothes, never flashing a badge, never even identifying himself as a police officer. That case factually does you no good.
Yeah, and I agree otherwise that the notion that scope of office equals scope of employment doesn't support what you and I are talking about here at all in terms of a disjunctive
Correct.
indemnification statute.
So well, two things. One, the Tepper case also uses the phrase office. It's the only case that we're aware of where the phrase office or employment or office or duties was ever interpreted. So to the extent that we're looking at that term office, that is the only case. With regard to Justice Baer's
Again, Tepper, I think Tepper, whether it's office or duties, just does you no good because of the factual distinguishments.
Well, but the thing is, in both that case and in this case, there were facts presented to a jury, And some facts supported finding under color of law and some didn't support finding under color of law. And in both of those cases, the jury evaluated those facts and the jury made a determination. And that's what at issue now is, what did that determination mean, not the facts that supported it. That we can never know what the jury was thinking about.
Let me ask you a different question. Putting aside Justice Donahue's very astute observation of the distinction between office and duties when you have a conjunctive between the terms, if we decide this case for you, don't we overrule a mountain of prior case law, as Judge Covey, I thought, pointed out on page 21 of her opinion, citing Hickenbotham, Western District case, Davies, Middle District case, Wash Pope, Eastern District case, Allegheny County Board, Western District case, Costa versus Roxborough, a Superior Court case, and on and on and on, all of which has said that there is a schism between under color state law and within the scope of your duties, which is your fundamental argument. And again, it seems to me your stream is putting aside Justice Donahue's point, which I think is well taken, I'm going to have to think about. It just seems to me that the case has already been decided and arguably should be IG'd rather than decided.
So I can't put aside Justice Donahue's point, because it is exactly the point, which is that every single one of those cases was decided under the indemnification statute. Every single one of those cases was decided under the immunity statute. They were all decided interpreting the phrase scope of duties. In every one of those.
We understand your argument. If you want to elaborate a little bit, go ahead, but I think we got it.
Well, let's assume it's correct. When does the municipality get to show willfulness, wantonness, maliciousness? When does that opportunity happen?
Under the statute, that has to happen in the underlying damages trial.
Well, see, again, then, and I understand why you're reading that, but that basically forces a municipality to intervene in every action. But there's nothing in the statute that says they have to.
The statute does say that they have to, by saying that in an action for damages in which it is judicially determined that the act constituted a crime, fraud, or malice, that indemnification won't be provided. So under the statute by its term says that needs to be decided in the damages action. And frankly, when you look at the purposes of the indemnification statute, the purpose is to protect employees, to allow them to do their jobs without fear of personal liability. And when you give unlimited discretion to the city to challenge indemnification.
That's correct. I just want to interrupt you before you go on. How is this police officer doing his job at home at night with his wife and baby? Somebody pulls a Halloween stunt, chases him in plain clothes, no gun, no badge, never yells, police stop, never does any of that. He's just a citizen, chases him down and beats him up. I understand why you want indemnity, but he doesn't look like a police officer under those circumstances.
But the federal jury heard all of those facts, and the federal jury, and decided he was acting as a police officer and not as a private citizen.
You still come back to under color state law means the same thing as under the scope of your office, let us say, Justice Donahue's. But we got that point. Okay.
Counsel, can I follow up on the first question I asked you about the decision by the city of Pittsburgh to tender a defense in this case? Is that evidence of a determination by the city that he was entitled to indemnification?
I think that the fact that they appointed separate counsel because they were required to under their contract with the Fraternal Order of Police. So that's why they did it. But the fact that they continued to be involved in that case, even after they were dismissed as a defendant, the fact that they sat in on council meetings between Neidig and his attorneys.
Who is they continue to be involved?
The City of Pittsburgh Law Department. Their attorney sat in on council meetings between Neidig and his attorney. They sat in at the charge conference. They were given the opportunity to include any instruction that they might want, that they might think was necessary at the charge
You
conference.
mean counsel for the city remained in the case even after the city was removed?
They did. They continued to, they remained in the case.
They had no client.
They did not, but they were participating in Neidig's defense. And we cite.
Okay, but they were representing Neidig. They weren't representing the city.
Well, no, they were not representing Neidig. They were representing the city. They were just assisting Neidig.
But the city wasn't a party by that time.
Correct.
How can they represent a non-party?
They were just participating. They were not representing any party.
Okay.
They were the city's lawyers.
They weren't representing Neidig. They weren't representing the city. They were gratuitously sitting in the room.
They were the city's lawyers. They were representing the city's interests. The city wasn't a party. You're probably correct that the city should have had no involvement in the case after the point that they were dismissed. But that's not what they did. Instead, they continued to involve themselves in the case. They continued to support this defense by Neidig that he was not, he was acting as a private citizen.
Maybe they knew that there was a chance down the road that there would have to be an indemnification issue, and they wanted to they wanted to possibly limit damages or limit attorney's fees. They weren't necessarily conceding that he didn't engage in willful misconduct or was acting within the course and scope.
Well, what they were doing is they were supporting his contention that he was acting as a private citizen and was not acting under color of law.
Which is the defense, the color of law.
Right, which they lost. And so now they're trying to do it again.
I think we've got it. Actually,
Okay.
from the other side.
Thank you, Your Honor.
Thank you. Ms. Corrin.
Thank you. If it may please the court, my name is Julie Corrin, and I represent the city of Pittsburgh in this case. The main issue in this case, I really think, comes down to whether the words of the law matter. And the answer to that question is that they do. If this appeal were to be granted in favor of appellants, this would require municipal employers to somehow simultaneously ignore underlying damages actions and actually participate and argue against their employees in these underlying damages actions. It would frequently rob Pennsylvania courts of jurisdiction over their own laws, the Tort Claims Act. It would also require federal courts in many instances to undertake supplemental jurisdiction that they might otherwise ignore. It would require courts to determine a hyperfactual issue of the scope of office or duties or the scope of employment as a matter of law rather than an issue of fact. The reality is that affirming this appeal would not change the overall ability for employees under the Tort Claims Act to be indemnified when they're working within the course of their office or duties. And just a couple points to make right off the bat. First, we know from some of the Supreme Court cases that are at issue in this case, like Rank, Wehagen, Pettit, that the term scope of office or duties is often used interchangeably with the term scope of employment.
Where is that? Where is that? And I'm interested. I mean, I'm asking, really, where is that?
If I could just...
Scope of office and duties is used interchangeably with scope of employment.
If I may just refer to my brief, Your Honor.
Sure, absolutely.
And you can tell us what page on your brief, because we do have them.
Thank you. Actually, I do have that page.
And the phrase is office or duties in the...
I believe so, Your Honor.
Disjunctive, yeah.
Yes, it's disjunctive. It's office or duties in the indemnification statute.
Correct.
On page 7, I have a footnote where the court and the Commonwealth Court use the term scope of employment and scope of duties. So, yes, office, well, interchangeably with the term within the scope of his office or duties as it appears in 8548. So I would just cite to Wehagen v. Braddock.
That case uses the phrase scope of duties.
I want to be precise, so I'm going to just refer to the exact location.
If you can't find it, you can write us a letter and tell us where it is.
Absolutely.
Thank you.
And I'm being quite sincere about, I'm interested if you found something that I did not. Because, as I look at this, the use of the phrase scope of office seems to encapsulate the notion of color of law. A police officer can make an arrest. It may not be within the scope of his duties under a certain circumstance, for example, Lombardi, but certainly a police officer can make an arrest. And as I read the jury charge in this case, and bless that jury because the jury charge on this issue is long and complicated, but one of the factors that they was asked to consider whether or not making an arrest brought the case within the context of color of law. And so I'm dissecting this for a reason, because I do believe that one can perceive an intent to cover two distinctly different circumstances. Officer Lombardi, Trooper Lombardi, was not acting within the scope of his duties, but certainly he was acting within the scope of the office of a police officer to make an arrest. So I think it's not semantics. I think it's a critical distinction for the purpose of this issue. And let me follow up with that, because here's where I'm a little bit concerned about this notion of having a separate trial. That's not what the statute says. The statute says that there is indemnification for a judgment. And to me, that means you look at that judgment. I mean, it doesn't say to be determined, indemnification to be determined after a judgment is entered as to whether or not the employee was acting within the scope of office, or because who knows? Two different juries can come to two entirely different conclusions when they're looking at even precisely the same set of facts. And what this statute is telling a municipality to do is look at the judgment and indemnify against it. And that's why I think there's just a tension with this notion that you impanel a new jury and you have an entirely new case, maybe different case, presented to a different jury. I just don't see how that fits together.
Just a number of things just in response. Page 22, we have the exact quote, and again, it says section 8548, so it specifically refers to the section, clearly and unambiguously provides that actions brought, I have an ellipses, brought against an employee where an employee was acting within the scope of his duties. Then later on in the case, they say was acting within the scope of his employment. So there's the duties, and then we have in Pettit the indemnification provision, which includes the word office, used, and then again within the scope of his employment. So
I get that. I agree with you entirely. Duties equals employment. Office does not equal scope of employment.
I don't know if there's any jurisprudence that would say that one way or the other necessarily.
The term hasn't been.
And
Well, why don't you answer Justice Donahue if you could for us? Just tell us, in your view, are, the legislature oftentimes uses extra words and says things 14 times when it shouldn't. Is there a distinction between office and duties when applying the statute?
I believe it was encompassing language to include, so the Tort Claims Act does not just apply to police officers in Pennsylvania. It applies to municipal employees of local agencies, which would include individuals who are elected to office. Now, I've never heard a police officer's job as a patrol officer referred to as an office, and I would still argue that when examining the case law that we have before us relating to the Tort Claims Act and then comparing it to color of law, that the two things are very different. Regardless necessarily of the term office, there's no office that Mr. Neidig held at the time other than being employed incidentally by the city of Pittsburgh. I want to make two other points, that there is a dispute over whether he actually made an arrest. Once he caught up with him and there was an argument, the two proceeded to a house where he, outside of the presence of the plaintiff in the earlier action, went into another person's house and called the police, and another officer came and arrested him and went through the criminal proceeding.
He detained him. It's an arrest.
You could consider it that way. I don't know if it's necessarily the same thing as an arrest, as it should have proceeded under the policies of the city of Pittsburgh within their course and scope of their officer duties or employment.
Officer or scope of employment, I agree. And as I read the federal jury charge, I really didn't see another consideration that was given to the jury that they could have found to be color of state law than the act of making an arrest.
And, well, that is...
I don't know if you tried the case. I mean...
I did not try the case. I was not involved. And I do want to make one other point about the payment of defense that came up. The city of Pittsburgh there's nowhere in the record that would show that the city of Pittsburgh paid for the defense. The Fraternal Order of Police Legal Defense Fund paid for the arrest. And the individual who represented Mr. Neidig at trial testified in the trial in Pennsylvania State Court that he took the case over from an individual named Brian Campbell, not that he was appointed by the city of Pittsburgh. So that, I do think, is an important distinction.
Brian's represented the fraternal ordinance and police for about 50 years.
Yeah,
Okay.
Thank you for that clarification.
Thank you. And I do think it's...
I couldn't determine from the record what it transpired there, so thank you.
And I believe that this just comes back to our question, like you said, when you look at those jury instructions, the jury was given a list of factors to consider about whether they could determine that Mr. Neidig was working within the color of law at the time that he committed the acts he was accused of acting. In those jury instructions, there's no way for us to know which factors the juries did in fact, other than guessing, did in fact consider or did not consider. And in particular, the one factor that they were considering that refers to his employment says, however, he could be acting as a private citizen. Under the statute for 1983 cases, individuals who are acting as private citizens could be acting under color of law when they're cloaked with the power of law from the state, like Mr. Neidig would be because he is a police officer under the Municipal Police Jurisdiction Act, who happens to be employed at the city of Pittsburgh. So those, again, are two different places and sources of authority.
They would be, but it's still acting under color of law. And that's what I mean about this problem of retrying the case, because we don't know what the federal jury actually found. All we know is that they found that Officer Neidig was acting under color of law. And so then the question is whether the indemnification statute, as written, covers that judgment.
And the answer to that question is no. And I would point to especially Rank in this particular case. Although it was addressing more the issue of willful misconduct than the scope of employment. Scope of employment was stipulated or agreed upon between the parties. In that case, the individuals who were objecting to his indemnification were relying on a verdict and punitive damages alone. And a verdict would be from a jury. So we know a judicial determination could come from a jury from that case. There was no ruling saying that this wasn't from a judge or it has to be done over by a judge. So once that came forward, the court in Rank said that there could be different inferences drawn, that an intentional tort of assault and battery does not automatically equal willful misconduct because there are two different definitions and there are two different sources of law. The same analysis happens here, and that's why we have issue preclusion, that's why we have collateral estoppel, to determine whether the facts that were put forward in the federal case that were tried and considered by the jury, the ones that we know of, which we don't know all of them, and if any other, and I believe this is some language from Justice, if any other inferences or conclusions are in dispute, that it is appropriate to determine those issues of employment in particular, and the case of whether someone was acting within their course and scope of their officer duties or employment in this case is often a question for the jury if there are issues and inferences that can be made differently in different contexts. So there was...
In the Justice versus Lombardo situation, the reason why the issue came up there is it was not indemnification, it was an immunity determination. Right. So you would normally decide immunity, which is a defense to the claim in that context. Here, indemnification is not a defense to a 1983 action. It wouldn't normally arise, and I would love you to expound on the point you made at the beginning, which if this approach is correct that the appellants are arguing, that the city would be placed in the untenable position of, on one hand, having to defend a police officer, while on the other hand, bashing the police officer or other municipal employee for engaging in willful misconduct to preserve any issue to avoid indemnification. You'd have to take both incongruent positions in the same federal litigation.
Even in state litigation, if a similar case has been brought in under Pennsylvania law, which it could be, but is very often brought under federal court. And I think, I'm sorry if this answer will be long, that it's important to examine what the city, as we're saying, was doing at the federal case. In the federal case, there were multiple claims brought under 1983. One was against Mr. Neidig individually, saying he acted under color of law. We've already talked about that. The other case or other claim was against the city as a municipal corporation, saying that they had a policy or custom that caused the officer to cause the injury. At summary judgment, those issues were decided and the city was dismissed. The city was not a party. Whether or not attorneys showed up or showed interest and discussed the case with the counsel who was trying the case for the employee does not mean that they undertook representation, that they had a duty to come and open their own case. There was no cross-claim against the city. There was no claim for indemnification under a cross-claim from either party, where there could have been. While maybe there's an argument that there was an opportunity that somehow this non-party could come in and say, I want to put in jury instructions or do more in the trial, there's no duty for the employer to do that. And it would be extremely prejudicial if employers had to go to their employees' trials and essentially argue against them. And also argue factors of indemnification on payment, because those issues are often bifurcated in state and federal trials. In criminal trials, whether or not someone is represented by a public defender is completely kept from a jury, because those issues of who pays who and who's actually going to be responsible for the monetary amount that may be ordered in damages can be extremely prejudicial when it's heard to a jury, because it could affect their reasoning about whether or not someone was liable. It could affect their reasoning as to what amounts they would find someone liable for as well.
Counsel, just one follow-up question on that. Did the City of Pittsburgh's council participate in court conferences after they were dismissed from the case?
Not that I know of. I mean, I don't know. I think there was an opportunity. I didn't work for the city at that time.
I thought I read something in the record that they were asked whether or not they wished to submit any jury questions.
And at that time, if the issue is that somehow they didn't submit something that they were not otherwise obligated to submit, or else risk waiver in a later case, there's another issue, because the issue of indemnification doesn't become ripe until there is a judgment. So it's putting the cart before the horse to say they had to show up there, they had to put in a jury instruction, because it wouldn't have just been an instruction, it would have had to be a special interrogatory as well.
And it would be nonsensical if they're not a party.
It would be, yes, it would be illogical, it would be nonsensical. It would go against really a lot of the settled jurisprudence of the basic way our case law moves forward. Our overall argument is that it was tried. The issues of the 1983 claims were tried in front of a judge at summary judgment, essentially, and then a jury. It moves forward, and there was a declaratory judgment action, which permits jury trials. At summary judgment, the question of whether or not the city was stopped from proceeding with the question of whether Neidig was acting within the course and scope of his office or duties or course of his employment was not decided, and it was disputed. It went beyond summary judgment, and it is a factual question, a very factual question, as we can see from these other cases dealing with very similar issues.
We haven't talked about it at all, and I think we're about done. But as a legal matter rather than pragmatic matter, for the city to be stopped, your word, there has to be collateral estoppel applicable, doesn't there?
Yes.
And therefore, there's an entire, I don't want to get into it at this point, but we know it, entire test that they would have to meet before they could assert collateral estoppel against the city.
Yes, and I don't believe that any of them, not only do all of the elements have to be met, but it doesn't look like any of them were. In conclusion, and obviously unless you have any other questions, I'll just say that even if the argument that this is a purely legal question of law that was decided by the federal jury and then just needed to be kind of cleaned up by our judges in a declaratory judgment action is your conclusion, which we obviously disagree with. I believe that there's still an issue with even having the elements necessary to show that. And this is an issue we brought up since summary judgment in front of Pennsylvania state courts, is that the elements of 8548 for indemnity have language that matters. We know that there has to be an action brought against an employee of a local agency for damages on account of an injury to a person or property, and he has to give timely prior written notice to the local agency, and you have the judicial determination. We have no evidence anywhere in the record that there was a timely prior written notice to the local agency for indemnification. And there's been argument that the judgment alone was enough, or that because the city had been dismissed and had this opportunity to put in an interrogatory that would be illogical to do, that somehow that alone constitutes written notice. I would disagree. We cited a case, I believe it's Dixon, where they talk about an individual who was seeking reimbursement for legal fees under the Tort Claims Act under a different section, and because that person had not submitted timely written notice requesting the reimbursement, that they were denied from doing so. And I would argue that outside of all of the other arguments that we made in our brief and that we incorporated here into our argument today, that even if the court were to agree with appellants on this issue, that their claim for indemnification would still fail.
Thank you very
I
much.
want to thank you very much for your time and attention here.
Very well argued by both sides.
Thank you.
The court's going to stand in recess for 50 minutes until 1:15, and we'll come back and hear the final case. You've been sitting here a long time. Yeah,
You too.
I apologize for keeping you waiting. One never knows how long the cases will go. And you hate to call a lunch prematurely, but we were at the point that you would not have had fair attention to your case. We granted review in this matter to explore what constitutes sufficient evidence to support convictions for theft by deception and home improvement fraud. Appellant, who was convicted of these crimes when he entered into a contract to install a roof for a condo association, but failed to perform the project, at least fully, and we can argue as to how much. He argues that the Commonwealth failed to prove he acted with specific malice to deceive or defraud the condo association at the outset of the contract, which he asserts are elements of the theft by deception and the home improvement fraud. Mr. Ging?
Thank you, Your Honor. Good afternoon. May it please the court and Ms. Ivory. I'm Brandon Ging from the Allegheny County Public Defender's Office, and I represent Mr. Donahue in this matter. Over the past 2 days hearing arguments, a lot of the cases before you were novel issues, issues of first impression, asking you to interpret particular provisions of statutes that haven't been addressed before. Oddly enough, in this particular case, I'm asking this court to reaffirm what I would argue is firmly established law that has been in existence since before I was born. I won't put my age on the record, but I've been around for a little while. Both crimes, as Chief Justice indicated, one was theft by deception, the other was home improvement fraud. They're obviously different and distinct in certain ways, but in a lot of ways in this particular case, they're one and the same. I will attack them separately, but I understand our conversation may blend together. So my first point with regard to the theft by deception statute is it's a specific intent crime. My client was convicted under 3922A1, and that reads, quote, "A person is guilty of theft if he intentionally obtains or withholds property of another by deception. A person deceives if he intentionally creates or reinforces a false impression, including false impressions as to intention." And this is important. "But deception as to a person's intention to perform a promise shall not be inferred from the fact alone that he did not subsequently perform the promise," end quote. If you look at 302 of the Crimes Code and how that defines intentionally, and both intermediate appellate courts of Pennsylvania have defined this crime as a specific intent crime. So I think that there's really no dispute in that regard. The second point, and I think this is particularly critical in this case, is the criminal information filed by the Commonwealth here. As we know, the purpose of a criminal information is to put the defendant on notice of the facts and crimes that he has to defend against. Formal notice is required, so he knows exactly what the accusations are, and ultimately, if a conviction follows, he knows exactly what he committed. If you look at Rule 560B3 of the Rules of Criminal Procedure, it states that a criminal information to be, quote, "sufficient in law must include the date when the offense is alleged to have been committed, if the precise date is known," and it has some other language. In this particular case, the Commonwealth's criminal information uses two dates. It says here, the Commonwealth's criminal information alleges that Mr. Donahue committed the crime of theft by deception, quote, "on or about Thursday, the 16th day of March 2017, through Thursday, the 23rd day of March 2017. The facts will bear out that those particular dates are, the first date is the day that my client entered into the contract with the association. The second date is when he deposited the $8,000 down payment check. So if you take that criminal information to read it the way you must, that he intended to commit this crime the moment he entered into this contract, that it was his specific intention from the word go to never install this roof. They didn't charge this crime as over a course of periods of time. As it happens, I believe the police are finally called into this matter in August of 2017. They didn't charge it that the crime occurred over that entire period of time. They didn't charge it when my client was approached by the association in June to find out what the issues were, like why wasn't the roof installed yet. They charged it in such a way that it was his intention, again, from the word go, to never fulfill this contract. And I think that's very critical.
Where in the statute is that required?
I'm sorry?
Where in the statute is it required that the crime only occurs if it occurs at the moment of whatever, the beginning of a relationship between the defendant and the condo association.
I don't believe the statute itself references that one way or the other. Ultimately, I think you have to marry the theft by deception statute to what is in the criminal information. They've decided when they charged this case that he committed this crime the moment he agreed to put this roof on. Yes.
If you look at the statute, the exact reading of the statute says a person's guilty of theft if he intentionally obtains or withholds property of another by deception.
Yes.
Is the complaint not an indication of exactly at what point in time your client obtained the property of another, and the length of time just shows the intent of his deception, the specific intent to deceive? I fail to see your argument carrying any weight with the language of the statute unless you can challenge my position.
Ultimately, again, and I apologize if I'm regurgitating the same argument, when I took this appeal and I read the criminal information, it really jumped at me. Like, their argument is that he intended to dupe these people as soon as he entered into the contract. And I don't in any way, shape, or form think that the evidence that bared out at trial supports that. Certainly not at the proof beyond a reasonable doubt standard, which is the highest standard for obvious
We're far
reasons.
away from the question we granted on, and it's forcing me to dredge my memory, and fortunately I have colleagues, but I don't think that you get to hold up that criminal information with mathematical preciseness. I think that the proof can modify the pleadings. I think it should be reasonably interpreted. I think the issue before the court is not did he violate the criminal information, rather did he violate the statute. Do you disagree with that?
I don't disagree that sometimes you can't pinpoint crimes, and they do offer for periods of time over a course of months. You oftentimes see that in sex offenses involving juveniles, things like that. But be that as it may, they decided to pick two dates. They could have charged this from March through August when the police were called, but they elected not to do that.
Did they try the case that way? If we read the record, do they limit themselves to proving theft on a given date?
They don't, and I don't disagree with part of the Commonwealth's argument that my client's conduct throughout this relationship is not irrelevant. I don't disagree with that. But I do think that they put so much emphasis on what happened far down the road without really realizing the way they brought this case. And
Counsel,
yes.
I'm a little lost in your argument.
Sure.
I thought really the only issue we were here on, and to me it seemed like an evidentiary issue, which is simply, did the Commonwealth prove its case with evidence other than mere non-completion of the work?
I agree with you.
That's what I thought that's why I got dressed up in my best robe today.
I agree with you, Your Honor. Obviously, I don't think the criminal information is necessarily dispositive, but I think it's an important consideration. But to your point, mere non-performance, and I think the case law firmly establishes that, from this court's decision in Gallaway in 1977 to the Bentley case in the Superior Court in 1982, that merely not performing on a contract by itself is insufficient to establish intent. And I understand, having done this for a while, you can find 5 cases that help you and 5 cases that don't. And it's really trying to figure out which facts.
See, you just put your finger on, I think, one of the most challenging aspects, or the most challenging aspect here. Let me ask it this way. Let's just assume for the sake of argument that you prevail in this particular appeal.
Yes.
I think we can agree these statutes have to mean something. Could you tell us what elements or facts would have had to be present here in order to support affirmance? Because when we decide this case, whichever way it goes, sure. We're hopefully going to be shedding some light on how these statutes can appropriately be handled, I guess, in this Commonwealth. And I think that's very challenging because there are matters of degree. Is it just a question of it can't just be a question of let the fact finder just spitball it, right?
I would hope not. I mean, I'll be honest with you. When I was putting together my Aplt petition, I was struggling to find a way to not frame this as error correction. And I understand as a policy.
Let me ask you this,
yes.
because one of the things we're trying to capture here is a statute we've never spoken to, and that seems to be getting lost in the shuffle. About the home improvement fraud, back to Justice Weck's
Yes.
point. I mean, you seem to be making the argument that the elements are the same for a conviction under subsection A of the home improvement fraud statute and theft by deception. Is that your argument?
My argument is they have the same intent element, that it is a specific intent crime. They obviously have different elements in other ways.
Yeah, but what's interesting here is you folks handle theft by deception cases all the time, but excuse me, I suspect it's much more rare that you handle a theft by deception case in tandem with this act under Title 73, and that's really where the rubber meets the road here. Is there any definable standard for how these home improvement fraud cases, whether charged just under Title 73 or with the add-on in the Crimes Code for theft, or is it just a jigsaw puzzle patchwork where these cases will go to guilty and these cases will go to not guilty?
Unfortunately, it almost seems like it is potluck. That as much as I appreciate the facts will drive the decisions, in addition to handling our appellate division, I also continue to do some preliminary hearings and stuff. And it's shocking to me how many times you see these types of cases brought in the criminal field. I'm not suggesting that these can never be criminal, but I'm also hoping to make an emphasis that they don't always need to be criminal.
Mr. Dean, let's try to narrow this down a little bit.
Sure.
The Commonwealth won this case below. Otherwise, we wouldn't be here.
Correct.
And therefore, they get the benefit of the facts and the inference of the facts in the light most favorable to them, which is always important in reviewing these cases. So given that, looking at the two statutes, what element, and we can pick either one you want, either theft by deception or home improvement fraud. Pick a statute and tell me what element the Commonwealth did not prove, given the appellate standard for review.
I believe in both cases the evidence failed to prove beyond a reasonable doubt that my client had this specific intent to deceive or defraud. And
again, no, it's okay. That's a good answer, and that helps us, I think. They get the inferences from the facts. So again, just quickly, that he went to the meeting, he agreed to do it.
Correct.
That he cashed the check for $8,000. That he talked to them for a period of about 6 months that he was going to get to it. He went to a second meeting and said, I'm going to do it now, and then never took another phone call, etc., never returned the money. Why isn't that enough to show specific intent?
I disagree with respect to the summation of the evidence, because I think there's a lot more to it than that. Ultimately, he did take the $8,000, I apologize, and he used it to buy the materials. He used $4,500 of his own money to pay.
I know his story, but the problem is the jury didn't buy it. But go ahead. I don't want to interrupt you.
I mean, this is one of my responses in my reply brief. I totally agree about how sufficiency claims are considered on appeal. But sufficiency claims also require review of the entire record. So where the Commonwealth fails to push back or chooses not to push back, I don't know how that doesn't get considered.
Well, this question may go more to whether there was a civil case than whether there was a criminal case, but they never asked for a refund of the $8,000, the condo owners, and he never gave them any refund?
That was something
Can you explain that to me?
That was something that the Superior Court found, and my reading the record wouldn't support that conclusion. He had testified, I believe one of the witnesses, the Commonwealth only had 2 witnesses in this case. Yeah. They testified that they never asked him for the money back, right. That they did meet with him, but they specifically said, no, not when are we getting our money back, just to meet to try to find out, like, what's going on with the progress? When are you going to start this again? And then my client testified, and this is why I think it's important, there was no pushback from the Commonwealth. He said, hey, when we had that meeting, as much as I assured them, I explained I had some family tragedies, had a back issue, we had some issues with the materials. He assured them he would see through the project. And at that point in time, he did offer to return the money. There would be a 15% restocking fee, but he's like, I can make you hold it the best I can. And they said, no, just keep doing the project.
We'll just have you arrested.
30 days later, that's when the police got involved, and this was another fact that was overlooked by the trial court and the Superior Court. The police approached my client, and they said, "Are you Brian Donahue, the foreman?" And he was honest. He said, "Yes, I was." Gave him all the correct contact information, as he did with Ms. Mystic and Mr. March. And they specifically told him, "Well, criminal charges are coming down the pipeline, so you might want to refrain from further contact with these individuals." And he did that.
Counsel, can I get a little bit more specific
Sure.
about this? I don't know, maybe I'm confused. The home improvement fraud crime has multiple parts. Your client was charged under A1.
Correct.
Okay. Now, why aren't we talking about that? It requires him to make a false or misleading statement to induce, encourage, or solicit a person to enter into any written or oral agreement for home improvement services.
Correct.
It says nothing about failure to perform is not evidence of intent to defraud or anything like that. It specifically says what has to be proven in order to make out a case for A1. Make a false or misleading statement. What is the false or misleading statement that your client made in this case to bring him into A1 of the home improvement?
I can only surmise that it was the Commonwealth's theory that by entering into this contract at all, that was the false or misleading statement.
What about the comment that he said he would take 6 weeks to perform, was it 6 weeks?
6 days, Your Honor.
6 days to complete it. And then subsequent to that, he then gave another excuse. And in furtherance of the deception is that he bought some equipment or some material necessary and then continued until the threat was made, hey, complete it, and then there was absolute silence. That the jury, I would
It's a
assume,
bench trial. Bench trial.
bench trial. The finder of fact would have, I presume, thought that is in fact the false impression that was corrected that he previously created and failed to follow through, or at least influenced such that A1 of home improvement fraud, as well as subsection 3 of 3922, where he failed to correct the false impression which the deceiver previously created or reinforced. I assumed they were the facts that are substantially part of the record
So
to
the
prove
judge,
the convictions.
so the judge drew an inference.
Oh, absolutely. That's my that's my understanding of reading of the facts.
Of course, the judge nor the Commonwealth ever talks about the specific provision of the statute that he was charged under. I think Justice Doherty is correct that is that one such false or misleading statement that induced the victims to enter into this contract.
That's what brings me back to the criminal information. That they didn't charge him as committing a crime at that June meeting. That is where you committed that false or misleading statement. They charged it in such a way that it was false or misleading the moment he entered into the contract.
You're making a due process argument, not a sufficiency argument. You're making a notice argument when we weren't aware of.
With all due respect, I'm not claiming that at all. I'm claiming, say what you mean and mean what you say. They said the crime was committed when he entered in this contract, and I'm looking for evidence to support that beyond a reasonable doubt.
As I understood your argument, and maybe I'm drawing a contrary inference, but I understood your argument to be, well, he may have had a good intention, and he didn't intend to deceive at the beginning. He thought he could meet these responsibilities. He took the money in good faith, and for various reasons not involving fraud or dishonesty, he was unable to complete the project. Is that what you're saying?
You have said it much more eloquently than I have today.
Thank you.
And I wish I had $1 for every home contractor with that story. Was the $8,000 total consideration, or was there going to be additional money?
No, as I read it, there was an additional approximately $15,600. He never asked for it because he admitted when he testified that was only due upon completion of the project. At the end of the day, and I think, I'm sorry, Your Honor.
Just let's get back to the language of the statute
Sure.
under which your client was charged. And let's put it in perspective. What the General Assembly clearly intended to do here was to encompass in 8 particular explicit sections of this statute to capture the most ubiquitous home improvement fraud out there and criminalize it. Whether we agree with doing that or not, that's what they did here.
Yes.
Okay, so A1 requires a false or misleading statement to induce, encourage, or solicit a person to enter into any written or oral agreement for home improvement. Obviously, that has to happen when the contract is entered into.
Correct.
Okay, so the dates that you keep referring to, you know, that's what he was charged with, that's what would be required under A1.
Yes.
Is it your argument that no false or misleading statement was made prior to the point in time that these people handed over $8,000 for your client?
Yes.
But to follow up on Justice Donahue's question, it seemed from reading Judge Bickett's opinion that he inferred that retrospectively from the non-performance, etc.
Yes.
He looked backward and inferred the intent to defraud. Now,
Yes.
I guess it brings me back to my question of some articulable principle that we can use, because without an articulable principle for these cases, it really seems to fall into vast prosecutorial discretion, and DAs across the Commonwealth can choose to prosecute the cases that strike them as the most egregious, or, you know, for whatever reason they have, and leave the rest to contract suits in civil court. And I'm struggling to see what it is about the fact pattern that is insufficient as a matter of law, thin though it may be from your perspective.
I guess my answer to that would be, when I was reading the case law, and it's specifically in the theft by deception statute, is non-performance alone doesn't get you there.
We aren't talking about theft by deception. I think we would all agree with you that that's what the case law says with theft by deception, but that's not what this says.
With the home improvement, yes.
A1 would suggest that if you made a promise to perform in 6 days and you didn't, the mere non-performance would in fact trigger a criminal violation, because the false or misleading statement was that you would complete it in 6 days.
And that's what I hope this is.
Correct? I mean,
I think it's.
Your argument is it doesn't matter which of these statutes. Mere failure to perform is not enough. And as I'm reading A1 under the home improvement fraud, it may be if you made a specific statement that this will be completed in 6 days.
I would only agree if it was again, I believe it to be a specific intent crime. It's not just, as Justice Todd had alluded to, like, I made a promise, I had all the good faith to see it through, and for whatever reason I just didn't.
But the problem you have is Judge Bickett inferred that specific intent from the facts, which you or somebody else might see differently. He's the fact finder, and what about it was insufficient as a matter of law?
Your problem is you lost below.
Sure.
You had a good story to tell, and the judge didn't buy it.
I mean, not that it
Why
matters. I
don't
mean,
you-
I was surprised that there was a conviction
Tell
at
us
trial.
anything you'd like to tell us and finish up.
Ultimately, these crimes, both crimes, they don't make it they don't criminalize being a bad business person. If that's the case, my client's guilty 8 days a week. They make it a crime to specifically intend to defraud or deceive somebody. And as I read this record, and as I acknowledge, he's not business person of the year. I said that countless times in the multiple briefs I filed. But he did take steps to own up to his end of the bargain. You know, among other things, using the money for the right reasons. He never used it for personal gain. He didn't go on a lavish vacation, things like that. And I would disagree with any reading of the record that suggests my client was willfully evading the association, anything like that. He offered to make them whole to the extent he could. He used $4,500 of his own money in an effort to get this labor through. His efforts were minimal. He told them it would be 6 days, and it clearly didn't happen in 6 days.
Well, nothing happened, right?
And I wouldn't agree with that. I would say nominal.
But the fair inference from this record is that this condo association hadn't gone elsewhere. They'd be sitting there with a leaky roof today.
And they would have I'm not a civil lawyer. I would venture to say my client is in hot water from a civil liability standpoint. I just don't see how this is criminal.
Well, and if I could just ask one last question. Certainly Judge Bickett was entitled to draw an inference, but his inferences need to be based on some facts in the record as of the time the intent needed to be demonstrated. And that's what I think you're arguing is missing here.
Yes, I would agree. Inferences are all certainly permissible, but they have to be based on facts established. And in this case, for instance, if the Commonwealth wanted to say, wait a second, let's talk about this $8,000. What exactly did you buy with $8,000? Tell me these crew members you put together. When did you go to these places? Tell me exactly what you did over the course of the couple.
That makes perfect sense, but the problem is twofold. Number one, here's the wording of the statute, and number two, here are the inferences that the fact finder drew. So, we could look at this all day and agree with Judge Sircone in his Gallo dissent, and hope that prosecutors around Pennsylvania won't, charge these cases all the time. But here they did. I don't know. Let me just shut up and let you talk.
No, why don't you finish up? I think we understand your argument entirely. I think we've probably been over it about 9 times.
I would just end with a last point for Justice Donahue. Because the home improvement fraud has little to no interpretation, I think it's important to...
That's why we took the case.
And I think...
Otherwise, we're engaging in mere
error correction. Correct. Yeah.
I mean...
And obviously, we can never take it when the Commonwealth, when the defendant prevails, because there's no appeal from that.
Sure. I think the important point with the home improvement is this is a specific intent crime. And that statement, the certainty of that statement is also imperative. I don't believe the Commonwealth in this case has met that burden beyond a reasonable doubt. And for the reasons I said before, I don't think they've met their burden with regard to the theft by deception statute either.
Thank you, Mr.
Thank you for your time.
Ms. Ivory?
May it please the court, my name is Margaret Ivory. I'm representing the Commonwealth. Not to oversimplify it, but as has been said, all the evidence has to be viewed in the light most favorable to the Commonwealth. And I would, in talking about what the agreement was, I would acknowledge that the witnesses don't give the most cogent testimony, but there are certain points that are very clear that they are in agreement on and that the defendant's testimony also supports. And that there was an agreement for the roofs to be replaced and that work would begin at the latest by April and that it would take 6 days. And in terms of the actual work done, their testimony is clear that nothing was done for a period of about 3 months.
Well, is there any testimony as to whether that promise of 6 days was relied upon or induced them to contract with him in particular over somebody else, or was it mere puffery?
No, I think it's a reasonable inference because the condo association makes it clear they needed this done as quickly as possible. And his
time of the essence was an unstated term of the contract.
I believe yes, if you go with their testimony as well as the defendant's testimony in terms of them contacting him during the off season, if they gave him the money by a certain time, and that he would begin it as quickly as possible.
So he clearly breached. The question then is, what evidence was there that he never intended to complete it within 6 days?
In addition to the failure to perform, as I said, he didn't approach them. They apparently were looking for bids. They needed a roof replaced, but he did ask for the money up front if they gave it to him by March 15th.
Does the record reflect that money was for materials only and that he expended it on materials only?
There's no evidence as to what it was expended on. That's his testimony, purely.
Okay.
Counsel, is a promise to perform within a particular period of time a false or misleading statement, or is that just a promise?
It's false when they're relying upon it and they entered into the agreement, and there's no reasonable effort to do it within any...
I don't know if that's true, and frankly, in your brief, you make a cogent argument that you charged under the wrong section of the statute. I mean, Section 2 of the home improvement fraud statute applies specifically to this situation. Receipt of advance payment and fails to perform by a specific date in the contract unless force majeure or labor strike or causes or extended by the agreement and fails to return payment received for such services. I mean, that's what happened here. That's an A2 violation, not an A1. A2 encompasses the promise to perform.
Correct.
A1 deals with a false or misleading statement. For example, I am an expert in flat roofs, in repairing flat roofs. I've done hundreds of them. And that induces this condo association to enter into this contract. That turns out to be a false statement. That's a breach of A1. Here, it just seems to me that A2 is the section of this statute that encompasses promises to perform that are not fulfilled. And as I said, I mean, the legislature went into excruciating detail on the types of home improvement fraud that they were trying to capture, and A2 seems to be the section of the statutes that most closely resembles what happened in this case. It's the argument you make in your brief.
I certainly point out cases that all the other cases seem to be charged under that section.
Under A2.
I think my argument also is that he made the false representations that this work would be done in a timely manner, and that's what induced them.
Or is that a promise?
It's a misrepresentation. It was a false. It was misleading, if nothing else.
Is a promise to perform a misleading or false statement?
When you know you don't intend to, yes.
So how do we know that he knew he didn't intend to?
It's all the surrounding circumstances. It's the fact that he responded in the way he did. He didn't do the work. He disappeared. He didn't communicate with them. That's, I think.
Somebody mentioned earlier that he may not, actually, I think his counsel referenced that he may not have been a good businessman, but even under these facts, he wasn't even a good criminal.
Yeah.
You know, I mean, but I mean, I'm struggling because Judge Bickett obviously viewed the evidence as the fact finder a certain way. I may disagree with how Judge Bickett did this. This does not look to me, if I look at all the facts of the case, if I were the fact finder, of a criminal act. Again, bad business person, bad criminal, but never, you know, he didn't abscond. He didn't use the money for purposes of it to pay other bills or things like that. There's no evidence that you would see of someone who from the get-go intended to deny these people the benefit of their bargain, but I'm stuck, and that may benefit you.
Well, I think there is a little more to it, though. I think there's the inference by the fact that he appeared at the property, showed his face, put some unidentified materials there, and then left.
With respect to the fraud and the inducement point my colleagues were getting at, we have Judge Bickett's statement that he inferred intent from defendant's actions and lack of communication, et cetera, et cetera. Let me ask you a similar question to what I asked Mr. Ging. If courts are to look to the totality of the circumstances, which I recall you suggesting in your brief, doesn't it end up just being basically something like courts just sitting in equity? I mean, is there any kind of predictability and uniformity that we ought to strive to articulate for trial courts that have to apply this statute in cases where DAs do bring these cases, which I assume is rare?
You're talking about home improvement fraud specifically. You're speaking about home improvement fraud specifically.
Right, exactly.
In my experience, it's very rare. I could only find certain cases that dealt with it. They dealt with it under the other section.
But is there a standard? It can't just be that the DA in this county X or county Y, doesn't like this contractor or does like this complainant, and therefore will go forward. Isn't there some sort of standard, or we just leave it to the unbridled discretion of the prosecutors?
Well, I think it comes down to, I think in that sense, it's similar to the theft by deception. It's very fact specific. I mean, obviously there are cases, many cases where the agreement is not fulfilled. And in terms of what exactly went on in this case, in terms of all through the pattern of it being repeated, where he said he was going to do the work and then disappeared, makes it specific facts that are chargeable.
Except I don't think the statute captures that, the home improvement fraud statute. I just don't think it captures that kind of run-of-the-mill, said he was going to perform and then he didn't. I mean, because that happens every day, I mean, unfortunately. I mean, that's why I keep referring to the fact that there's painful detail in 8 particular sections setting forth what the legislature was attempting to criminalize in the context of home improvement fraud. And if there's anything in this statute that covers the situation that happened here, it would be A2, under which he wasn't charged. And then we'd be having a different discussion, you know, about whether, you know, there was actually a contract. By the way, the contract isn't in the record, I might add. You know, so we're left to wonder whether or not there was a time for performance in the contract. So, you know, we have oral statements about when it was going to be, but what about the contract itself? Did it, you know, but we don't even get that far because he wasn't charged under A2. And I'm still groping for what the actual false and misleading statement was, but because it can't be a promise to perform that didn't happen because A2 covers that.
Again, my only response is that that he misled them into believing that they were going to get a much needed roof replaced in a reasonably quick period of time.
They knew the roof was leaking in December. You know, I mean, I understand what you're saying, but I mean,
I'm not sure
I've
what
had leaking roofs. It was leaking in December.
Your response is there were 2 sides to the story. The jury, the trial judge, Judge Bickett, is the fact finder, accepted yours, and there's sufficient evidence on the record to support it.
And you didn't draft the charging document.
Right.
Correct.
Right.
Well, it's as I read this spare and brief trial court opinion, the fact finder heard the evidence and then made his inference, drew his inferences, and reasoned backward retrospectively to find it was fraud in the inducement under A1. That seems to be what we have here.
That seems to be his, and there are certain statements he makes at the end of trial, I believe, that he felt that was the case.
Thank you.
Thank you.
I think we understand it. Good argument by both. Good session. We'll stand in recess until May in Philadelphia.